April. I have to be back to mention item number 14 and 15, my lord, in the hearing list. I appear for the private respondents here. My lord,
Item number
14 and 15.
12 and 13, sir. 12 and 13. This
Oh, change.
change.
Oh, I'm sorry.
12 and 13.
12 and 13, yes. 12 and 13. May I pray, my lord, in item number 13, my lord, we have to file a small affidavit also. Government has also not filed. And as it is, Mr. Pertin is also in bereavement. So can it be on 25th of April, my lord?
25th.
Yes, ma'am.
Okay.
After the bill.
Mr. D. Panging, learned counsel for the respondent. With consent from the other side, press for listing the matter on
25th of April.
25th of April. Fair allow.
Oblige.
25th is holiday, Lordship.
25th is holiday.
Holiday, sir.
Then 28.
Oh, yes.
28.
28.
May I please, Your Lordship,
Yes.
I beg to mention item number 2, Your Lordship. Here, for the last few days, learned senior counsel was here, so he left yesterday. Diganto Das, Your Lordship, senior counsel. So may I pray that this matter may be taken up after 2 weeks, Your Lordship.
After 2 weeks.
Lordship.
Mr. A.K. Singh, learned counsel for the petitioner. With consent from the other side, press for listing the matter after 2 weeks.
Lordship.
My lord, my name may be reflected in the
Fair
court
allow.
list. I am appearing for 5 to 13.
Mr. Z. Tarak, learned counsel for the respondent, number 5 to 13.
Yes.
Submits that his name has not been reflected in the counsel list. Rest shall do the needful in this regard.
Okay.
Yeah, please, my lord. My lord, I like to mention item number 11 on behalf of N. Anju. Matter may be kindly list after 2 weeks, my lord.
Item number 11.
11.
Is your name, please?
My name is O. Parme. I am on behalf of N. Anju.
O. Parme.
Yes, Your Honor.
Learned counsel appearing on behalf of Ms. N. Anju, learned legal aid counsel. You inform the other side?
Yes, my lord.
With consent from the other side, press for listing the matter on
After 2 weeks,
after 2 weeks.
my lord.
Okay. Fair allow.
Most obliged.
May Your Lordship, Your Lordship, I beg to mention item number 5, Your Lordship.
Item 5.
Yes. I have taken the consent, Your Lordship. May it be fixed after 2
Mr.
weeks.
Liam, learned counsel for the respondent number, learned government advocate for the respondent number
11 and 12, Your Lordship.
11 and 12. With consent from the other side, press for listing the matter after
2 weeks, Your Lordship.
after 2 weeks. Fair allowed.
Oblige, Your Lordship.
May I please, Your Lordship? Your Lordship, I may be allowed to withdraw item number 3, Your Lordship.
Item number 3.
Yes, sir.
Mr. L. Bam,
I Bam.
Ibam,
Yes, sir.
learned conducting counsel for the petitioner, submits that he has the instruction to withdraw this petition. Fair allowed.
Yes,
This contempt case number so and so stands disposed of on withdrawal.
much obliged.
Item number 1.
Yeah, Your Lordship, I'd like to seek adjournment, Your Lordship, because due to the sudden demise of Miss Giata's cousin, Miss Giata, government advocate, Your Lordship. Yes, Your Lordship. So she had to leave the court, Your Lordship.
Heard Mr. Lolan, learned counsel for the petitioner.
No.
Mr. Riam appearing on behalf of Ms. Z. Ite,
Yes, Your Lordship.
learned government advocate for the state respondent. Mr. Riam submits that Ms. Ite is on leave on account of bereavement,
Yes, Your Lordship.
and he pressed for listing the matter after.
After a
Lordship,
week,
fixed date may be given because I have urgency, Lordship.
Okay, suggested it.
Let it be on today's 9.
20.
6th April. Lord.
6 April. Okay.
6 is
Monday.
6 April.
Lordship, 6 is Monday. 7.
Oh,
7.
7 DVD. Lord.
7.
Oblige, Your Lordship.
Deeply obliged.
Item number 4.
May I, Your Lordship?
Yes.
I'm appearing on behalf of the petitioner, and
Yes.
also I humbly pray that for the respondent number 5, that is Deputy Commissioner Anini, I humbly request for the dusty service may be allowed.
PMWC can appeal.
And in respect of other two respondents, 6 and 7,
For the 6 and 7, we'll take a fresh step again. However,
Fresh
they are
step.
6 and 7 are the private parties. However,
Private respondent.
yes,
okay, okay.
PMG's one.
Your good name, please?
Your Lordship, my name is Emily.
Heard Mr. E. Millie,
Yes, Your Lordship.
learned counsel for the petitioner. Mr. Aris Nabam, learned additional advocate general for the state respondent. Being respondent number
2, 3, and 4, my lord.
2, 3, and 4.
Yes, my lord.
The learned counsel for the petitioner submits that he may be permitted to effect service upon the respondent number 5, who happens to be the Deputy Commissioner of Dibang Valley District, Anini, by the Stemut.
No, sir.
Where allowed, after effecting service upon the respondent number 5, the petitioner shall file an affidavit to that effect before this court. The learned counsel for the petitioner further submits that he may be permitted to take fresh step upon respondent number 6 and 7. Where allowed, step be taken by speed post and also by usual process within a week from today. Registrar shall list the matter after 4 weeks.
Well, the respondent number, I'm a bit confusion. Chief Executive Officer RWD are the secretary, it should be secretary RWD. There are so many defects in my lord respondents. In protocol, my lord chief secretary is the highest in the executive body, and he has been made respondent number 3. And the chief engineer, he is the my lord, chief executive officer. He has been made respondent number 1, my lord.
Okay.
I think that needs to be corrected by the petitioner, correct?
Okay. Mr. Tarak, your confusion is regarding
Respondent number 1.
respondent.
Even my name is also not reflected in the cause list.
Okay. Mr. Tarak,
The chief engineer.
learned standing counsel appearing for respondent number
1, it should be chief engineer, either secretary RWD.
Okay. Is arrived as respondent number?
1, my
Chief
lord.
One.
Executive, it's chief executive officer.
Okay. Submits that that he is appearing on behalf of respondent number 1, but his name is not reflected in the cause list. Registrar shall do the needful. The learned it is further provided that the learned counsel for the petitioner shall obtain necessary instruction in respect of arraign the respondents in accordance with their protocol
Protocols, my lord. Yes, my lord.
Yes,
and file amended cause title
Cause title.
before next date.
My lord, very well.
obliged.
Ticket.
Item number 6.
Lordship, here the legal aid council lordship submitted her letter of absence, lordship. She is not
Okay.
represented, lordship. It
Okay.
serial number 6.
None appears for the appellant on call. However, Mr. Loy, learned PP, for the state respondent present, and he pointed out that the learned legal aid counsel, one legal aid counsel, namely Z. Dozy, was appointed by this court, and she has filed her letter of absence. And he pressed for listing the matter after
2 weeks.
2 weeks.
Lordship, a small player, lordship. There is a connected lordship arising of the same judgment, lordship. There are two more appeal is pending, lordship. Before
Okay.
this may be clubbed together, lordship. I will furnish the detail, lordship.
Okay, Mr. Loy, learned PP for the state respondent submits that in against the same judgment and order, 2 other appeals are pending before this court.
Yes.
And he pressed for this criminal appeal along with those appeals. You furnish the list
Yes,
to
sir.
the
Deeply, please.
They are allowed, Registry shall do the needful in this regard.
Item number 7.
Please, Lordship.
Yes.
Lordship, here, I'm the legal aid counsel.
Yes.
I have perused the documents and I found that there is a delay of 145 days. And there are 2 victims and 1 information.
Mm.
So I need to file one condonation, delay condonation application here.
Okay. Heard Mr. Hugh Bori, learned legal aid counsel, and Mr. Loy, learned PP for the state respondent. Mr. Bori submits that having gone through the documents furnished to him by the registry, he found that there is delay of 145
45 days.
days in preferring this appeal. And he will file an application for condonation of the delay. And he plays for listing the matter after
2 weeks.
after 2 weeks so as to enable him to file the application. We are allowed recess and list the matter after 2 weeks.
Apply.
Mr. Bori
Lordship,
will fix a date
fiction that, okay.
because this is jail appeal. Can it be on 9th of April?
Okay, need.
9th of
Okay.
April? Okay, 9th of April.
Okay.
Item number 8.
May it please, my lords.
Yes.
I am on behalf of respondent number 14 and 15. We need 1 week time for filing objection because this road project does not belongs to us.
When you are going to file the objection?
1 week time may be given.
1 week time. Your name, please?
Eroy.
Roy. Heard, Mr. Your name?
Marge Lombi, M. Lombi.
M. Lambi, learned counsel for the applicant. Mr. R.S. Nabam, learned additional advocate general for the respondent for the opposite party number.
I'll be for respond number 1, 2, 3, 4, and 8 and 9, my lord.
1, 2,
1
3,
to 4 and 8 and 9.
1,
2, 3, 4,
2, 3, 4, 8
8
and 9.
and 9. Yes, ma'am.
8 and 9. 8 and 9.
Sir, from the petitioner side, if I may submit humbly, may I request the bench maybe please to graciously issue direction to the time-seeking council to make it a last opportunity because this matter is pending since last November and this isn't even main PIL. Just the interlocutory application for bringing consequential amendment because I was able to secure affirmative order from this court in order to bring striking off and impleading of necessary parties. Now this is just an amendment and the objection which the council is talking about, that objection can be filed in the actual petition. Affirmants are made there. So if this IA can be allowed today, I will file the amended petition and then they can file the objection. This is just an amendment seeking petition since November. And it's been more than, I think, 4 months, sir. And every time this matter comes up, the time is being sought. So it has rendered us helpless to move further.
Yes, madam.
My lord, this is last chance we are praying for. But if the amendment is to be filed, then it may be allowed. But we need to file our objection because we are not the party. We are not necessary party in this.
But sir, if I may submit, they have already been implemented. When it comes to the government's objecting, saying we are not the parties, implement and striking off have been done. This objection should have been brought in that stage. Now, since the striking and implement has been done, so I was directed particularly by this court to bring consequential amendment. So they are at the liberty to file that objection, even at when I will file the amended petition. So now it will render the order toothless and my petition toothless. And again, I will have to take step of again in pleading. So this is tangling the matter. So, sir, I will pray if the opposite council can understand my matter. This can be allowed today, and I may be directed to file amended petition and serve requisite copies to all the parties, and then they can object the main petition. If required, I will take fresh step. I will not hesitate.
Okay, no objection.
If I may direct, take your lordships to the order of the main PIL, order dated 11/11/2025, not the IA, original PIL, sir. Humbly, just that order will clear everything. I'll read one line. order dated 11/11/2025. I believe the council is in misconceived belief of the petition. I will read from page para 2. It is to be mentioned that by an order passed today in the connected IA, the name of the respondent number 5 in this PIL has been allowed to be deleted without altering the seriatim of the parties, and the names of parties whose particulars are disclosed in para so and so of the said IA are allowed to be implemented as respondents. So objection is no more required now. Now, para 3 says, on the prayer made by the learned counsel for the petitioners, he is granted liberty to file an appropriate application for consequential amendment of the PIL. The order for filing of the amended course title of the PIL shall be passed as and when orders are passed in the application proposed by the learned counsel for the petitioner for amendment of the PIL, so that all the amendments can be done at one go. So the intention from this order can be inferred that to cause convenience to the court as well as the smooth processing of the matter, I was directed to file course title amended and necessary consequential amendment in the body. So that certificate can be allowed, the petitioner respondent can still file objection in the main body. But their objection will not cause any justice in the matter because they have already been implemented.
But why don't you pointed it out earlier?
Sorry, sir.
After this order also, the matter was listed on 2-3 occasions.
And they were given opportunity to file objection with regard to amendment. Now the council is saying they will file objection with regard to impleading and striking, which has already been passed. Council is saying that we are not the parties, but parties have already been implemented in spirit, in essence. Now to bring it on record, and when the matter is listed in course title, their names are not being reflected because on record I haven't brought it, and that can be done through amendment only, sir. So in spirit and essence, they are the party here now. They cannot say we are not the party. Order has been passed. The order has to be honored. I believe council have just said she has no objection now after hearing my submission. She was in misbelief. I believe humbly, sir.
Yes, madam.
Yes, my lords, I have no objection about this. They can file their amendment.
Mr. Nabam, anything?
My lord, since beginning, my lord, I never raised any objection. My lord, it is necessary. This IA has been filed, my lord, as per the permission granted by this court to change the course that which is very important, my lord, and for implement, my lord. So that has been allowed, my lord. So your lordship can allow the IA, and the other side they can, my lord, bring out with compilation, my lord, this PL. Then they can raise objection, no doubt for that, my lord.
Okay.
I may be allowed, no objection, my lord.
So prayer is made in para 9 of the IS, sir. The necessary amendments to be brought. Para 9 A to G. Only H. Very small amendment. Para 9 A to H. We've been struggling with this matter, sir, since November.
Pardon me, sir.
M. Lombi.
M. Lombi, learned counsel for the petitioner. Mr. R.S. Nabam, learned additional advocate general for the opposite party number.
My lord, 1, 2, 3, 4, 8, and 9, my lord.
1, 2, 3, 4, 8, and 9.
Yes.
Mr. Tarak for
6 and 7.
6 and 7. Mr. Kato, you are here.
If the amendment causes the amendment to the
Allowed only then you will be party.
will be respondent number
Okay.
for 10, 11, and 12.
Okay. And Ms. A. Roy for the respondent
Now he'll be
opposite
handing-
party numbers.
14 and 15.
14 and 15. 14 and 15. This interlocutory application is filed by the applicant, who is the petitioner in the PIL number 19 of
2024.
Seeking permission to bring an amendment in the cause title as well as pleadings of the link case PIL number 2024 in exercise of liberty granted to the applicant by this court by order dated 11/11/2025 of the previous IA within bracket C number 203 of 2025. The learned counsel for the applicant submits that the applicants now intended to bring the consequential amendment of the PIL number 19 of 2024, and the same is reflected in paragraph number 9 from point number A to point number H. H, and that the same amendments are required to adjudicate the dispute being raised in this petition. And as such, he has contended to allow this application. The learned Mr. Nabang, learned additional AG, and also Mr. Tarak, learned standing counsel for the respondent number so and so, and Ms. A. Roy, learned counsel for the respondent number so and so, submits that they have no objection. Accordingly, taking note of the submission of learned counsel for both the parties and also considering the facts and circumstances on the record, this interlocutory application stands allowed. The allowed as pride for in paragraph number 9 from point number A to H. In view of the accordingly, this IA stands disposed of. In view of the IA file, in view of the order passed in this interlocutory application, now the applicant shall file amended cause title and also the amended petition with the petition within a period of 1 week from today.
1 week may be granted.
1 week from today. This is less the matter after 1 week.
Okay. Thank you so much, sir.
Blessed.
Item number 9 and 10.
My lord, the IA has been listed for impediment filed by one of the respondent parties who want to impede themselves in the matter. Otherwise, the matter
Please,
was,
my lord.
as per your lordship's last order, it was fixed for final hearing today. And there was lordship was grateful to grant us an interim direction that the result should not be declared.
My lord, this IA may be disposed of today since due to some personal reason I couldn't contest for this election.
Pardon?
Due to some personal reason I didn't file the nomination, my lord. I didn't contest for the election, my lord.
Okay.
Yes, I want to withdraw, my lord.
Or you want to withdraw?
Yes, my lord.
Okay. You filed this IA?
Yes, my lord.
Okay. Heard, Mr.
H. Takum.
Learned counsel for the applicant. The learned counsel for the applicant submits that he want to withdraw this. He has the instruction to withdraw this application. Where allowed, this interlocutory application stands disposed of on withdrawal.
Obliged, my lord.
If your lordship would kindly peruse the last order, my learned friend appearing for APSU submitted on the last occasion that the elections were going to be held this week, and it would commence and be over on 26th as per their notification. Now today is the 26th. If my learned friend could kindly appraise this court about the status of the elections, my lord. Otherwise, from what I have gathered from my instructions is there have been certain violence in the streets over these last 2 days.
There has been
certain violence in the streets, my lord, regarding the elections over the last 2 days. The earlier 2 days were peaceful. However, day before yesterday and yesterday, there were certain incidents of violence. So if my learned friend could kindly appraise this court before we start with the matter about the status of the elections, whether it is over, the voting is over or not, because your lordship has stayed the declaration of the results.
Yes, Mr. Kato.
We have filed our affidavit. Raising the maintainability also, and if lordship peruse the affidavit filed by the student body, there is a the clear cut the statement wherein the maintainability has been raised, Firstly, the petitioner is not neither the member of the student body, nor the aspiring candidates contesting in in any post, any of the post.
No, whether the election is over.
No, my lord. My lord, as per the instructions, my lord, due to complaint after complaint, my lord, the election process, my lord, the voting process was not done, my lord. It is done, started by now, my lord. The voting process, my lord. Altogether, my lord, as I pointed on the last occasion, my lord, altogether more than 5,000 delegates has been registered, my lord. And altogether, my lord, the 78 candidates are contesting for the post of, my lord. Altogether, my lord, 32 posts, my lord. So therefore, my lord, the election process, my lord, the voting process is still going on by this morning, my lord. It started from this morning only. And my lord, it will take time to, my lord, complete the election process, past voting, then after, my lord, immediately after completion of the voting, my lord, they will start counting, my lord. So therefore, my lord, it will take another, my lord, 3-4 days, my lord, time to complete the, my lord, process. My lord. In a ballot paper, my lord, more than, my lord, the 78 candidates are, my lord, in the, my lord, given, and wherein, my lord, each voter has to, my lord, choose their candidates. So it will be very difficult for them to, my lord, complete the election process within such a stipulated time period, my lord. So therefore, my lord, the student body, as per the instructions, my lord, the voting process is started by this morning, and it will, my lord, we don't know, my lord, when it will be completed, my lord. Altogether, my lord, the 5,000 voters in a single, my lord, the boot, my lord, single boot, my lord, it will.
So whether any untoward incident had taken place?
No, my lord, that is, therefore that, my lord, is on the last occasion, my lord, even I have not gone through the, my lord, that instruction, that, my lord, the sufficient, my lord, the police personnel has been deployed. My lord, admittedly, there will be, my lord, the minor altercation between the student body, my lord. After all, this is a student body organization, my lord. However, my lord, serious untoward incidents are not taking place, my lord. We all, as we have already pointed, my lord, all the candidates, my lord, the contesting candidates, they have given, my lord, the undertakings to the, my lord, the authorities, my lord. This district administration as well as the, my lord, home department, my lord. And rounds of, my lord, discussions are going on with the law and order problem situation, my lord. Now it is peacefully going on, my lord. So therefore, there is no such, my lord, the serious incident, my lord, where required to be, my lord, they stall the process, my lord. Moreover, election process is going on, my lord. At this stage, my lord, may I pray that, my lord, we may be allowed to continue the election process, and we may be allowed to continue the election process peacefully, even, my lord, by counting, my lord, after completion of the voting, my lord, we may be allowed to, my lord, declare the result, my lord. This is, my lord, something, my lord, again, my lord, interference in the, my lord, the peaceful election process.
Okay.
My lord, admittedly, my lord, it's a student organization, my lord, it will, my lord, some tutu may will go on, my lord. Minor altercation is definitely, my lord, it will take place, my lord. Well, let's just imagine, my lord, all together 78 candidates, my lord. And regarding, my lord, rest other parts, my lord, I'm sorry, my lord, I'll just, my lord, regarding other part, my lord, that, my lord, the application of the Lingdo, my lord, the committee report, my lord. To that extent, my lord, we have already demonstrated in our affidavit also, my lord, that is not applicable in our case, my lord. If lordship peruse the composition, the who will be, my lord, the members of the delegates has already been given in our also in our constitution also, my lord. The Lingdo committee, if lordship peruse the, my lord, if I take your lordships to the page number, my lord, 271. It is specifically in respect of campus university and the college, my lord, campus college, my lord. Universities, colleges across the country. Not for this student organization. This student organization is, my lord, such organization. It is constituent of, my lord, all the students' bodies across the state. It is not in respect of only one university or one college, my lord.
Okay.
So therefore, my lord, at this stage, my lord, just to complete, my lord, my submission, my lord. My lord, at this stage, what my prayer would be today, my lord, is, my lord, we may be allowed to peacefully complete the election process, till the my lord, declaration of the result also, my lord. And regarding other rest part, my lord, barrier, that will be, my lord, required to be adjudicated, my lord. We are also of the view, my lord, there must be certain things which has to be, my lord, the cover of the student body also, my lord. So therefore, my lord, let them, my lord, there will be definitely, my lord, will be required to, my lord, adjudicate the, my lord, the other legal aspect, my lord. But the two, but only in respect of the election process, my lord, we may be allowed to continue. We may be allowed to declare result after completion of the voting, my lord, polling, my lord. Thereafter, my lord, the result will be declared on the spot itself, my lord.
Okay.
May-
Yes,
may
Mr.
I-
Soder.
My lord, from the submission of my learned friend, Mr. Kato, it appears that there has not been any serious incidents. But there have been some incidents that have been indirectly admitted, number one. Number two, they have, your lordship have not, my lord, stalled the election process. Only thing your lordship said that the results should not be declared. And they are not very sure how long they will take to declare the results. When this counting will be over, when this voting will be over, they are not very sure. Now, they, my lord, all the respondents have in the meantime filed affidavits. We need to, my lord, respond to that because some legal issues are there, my lord. My learned friend, Mr. Kato, has said, my lord, these are to be adjudicated. So what I pray for is that let me respond to the affidavits. Your lordship will give a short time. And on the next date, perhaps your lordship may take up the entire matter for disposal. And since, my lord, it has fallen from his mouth that at least 4, 5, 6 days time will be, my lord, required. So let it come after a week. In the meantime, we file our response, and your lordship will take up the matter. Until that time, your lordship, perhaps, my lord, it will be in the interest of justice that the results should not be declared because they do not know. Even, my lord, it may take more than a week. So on the next day, your lordship may take up the entire matter for hearing, my lord. Here is a case where, my lord, the election of the, my lord, all Arunachal Pradesh Students Union is not confined to only to the students. It touches each and every, my lord, citizen of Arunachal Pradesh. And therefore, we have to take a view from above and see, my lord, why it is necessary. My lord, I'll show that they are taking constitution at different point of time, different constitutions are circulated. There has to be one. Now, the constitution that we relied, my lord, initially it was not opposed to, subsequently, my lord, another constitution has come up. How this constitution is, my lord, framed, that also, my lord, your lordship needs to examine. And here, my lord, is a case, my lord, not only this election, in future elections also, my lord, there should be some, my lord, mechanism by which, my lord, the reform is taken so that, my lord, this type of incidents do not recur in future. And therefore, the state has a role in that. We'll make all the submissions on the next date. Your lordship may fix it after a week. And in the meantime, we'll respond to the affidavits. And on that day, your lordship will, my lord, take up the matter for final hearing. And till that day, my lord, 1 week, because 4, 5, 6 days, they'll otherwise also take time for declaration of results. That is what the submission is. And therefore, let it be that interim order, because your lordship has not, my lord, stalled the election. Let the election process go on, and let the results not be declared till the next date, my lord. On the next date, your lordship will see if, my lord, everything is over. Maybe your lordship may permit them also, because, my lord, what we are on is not only this election, my lord. Every, my lord, 5 years, 4 years, my lord, this keeps on happening in the state, and this is not, my lord, conducive to the public interest. Therefore, this is my limited prayer today, my lord.
No, what purpose will be served if we withhold the result?
Yes, my lord.
My lord, I didn't get your
Mr.
lordship.
Chaudhary?
My lord.
Mr. Chaudhary, what purpose will be served if we state the declaration of result? Whether
In the
it
event
will
your
not
lordship,
create...
in the event your
No,
lordship
Mr.
finds,
Chaudhary, you say, if we state the declaration of result, even after completion of their voting process, would it not create another law and order situation in the state?
my
Because
lord,
of the court order?
it is, my lord, the the ground on which, my lord, they say that the election must be held is that more than 5,000 people from all over the state are stationed in Itanagar, and they are waiting for the election to be held, and they should go back after the election is over. And on that ground, my lord, one of the grounds your lordship considered, because they are here in Itanagar, and therefore your lordship permitted to hold the election, my lord, we also did not oppose to that. Now, after this, my lord, candidates go back. There is no chance of, my lord, any untoward incident. More so, my lord, when the state has filed an affidavit, in fact, two affidavits, my lord, showing how the entire process is being controlled by police personnel, paramilitary forces, and all. Therefore, there is no chance of any. And they have also given the undertaking. My learned friend, Mr. Kato, has said that they'll do everything peacefully. That undertaking has also been given by all the, my lord, candidates. Therefore, my lord,
Okay,
if
then,
even
Mr. Chaudhary will fix a date in the first week of April, so that they can complete the election process. And there is also no delay in declaration of the result. Can we fix the matter on Thursday, 2nd of April?
Well, any date convenient to your lordship. By the time we'll file a response. I don't think they'll be able to complete the election, my lord, the election by that time.
My lord, by second, my lord, we'll try to complete the election process. And that thing, my lord, even declaration of the result also, my lord. That's because day and night counting provision is there, my lord. Day and night voting provision is there. Now, my lord, even we don't want to, my lord, hold the election processes because my lord, many of the delegates are in the station for last 1 month, my lord, because of this, my lord, some other reason, my lord.
No, that's all right.
We
We'll fix the matter on 2nd of April.
Yes.
On that day, finally, matter will be heard and disposed of.
But my submission would be today, my lord, is, my lord, firstly, my lord, the maintainability, my lord. On maintainability, if, my lord, the
No, Mr. Kato, we are not hearing the matter on merit today. Let them file their affidavit in reply. We'll finally hear and dispose of the matter on 2nd of April.
Exactly, my lord. My submission is.
My lord, the most important part your lordship would like to ascertain is that, my lord, which is the constitution? They keep on publishing constitution one after another to suit their convenience. That is the most important part, my lord. That, my lord, after we file the reply, your lordship will consider that. We have relied on the constitution. Subsequently, they come to say, no, this is not the constitution. How many constitutions are there?
Okay.
My submission is.
No, Mr. Kato will stay the matter till 2nd.
My lord,
Till declaration of result.
My lord, again.
On that day, you come prepared on that day. Finally, we will dispose of the hear and dispose of the matter.
My lord, again, not to declare the result will again another matter, the interference in the election process. As because, my lord, what will happen to my lord?
No, we are not interfering in your election process. We are only saying that don't declare the result till the issues raised in this petition is decided. You come prepared on 2nd of April. Heard Mr. M.K. Chaudhary, learned senior counsel assisted by Mr. Bhardas.
My lord.
Yes, yeah. You are Bhardas, Mr.
P. Bharadwaj, Tapan Bharadwaj.
Yes, learned counsel for the petitioner. Mr. M. Kato for the respondent number.
I am for the respondent number 4, 5, and 6.
4, 5, and 6. Mr. Ratan, learned
1, 2,
additional AG
and
for
3.
the respondent number.
1, 2, and 3.
1, 2, and 3.
My lord, may I make a small submission, my lord?
Yes.
My lord, although the state does not have any interest in the with regard to the issues within the APSU, but ultimately it is the state who has to look after the law and order problems, and it is the citizens who are facing these troubles. Now, we are not concerned about this election only. We are concerned that in future also, if there are elections to come, this honorable court has to give some direction that how to go ahead with such election, because ultimately in all sorts of elections, student selection, it is the state and the citizens who suffer. Now, for that matter, whether the Lingdo committee's this report will be applicable, or even if not applicable, whether there can be a sort of direction from this honorable court how to go ahead with such election, and what the role of the state and what the role of those who are going to conduct that elections. That has to be decided. We are not concerned with this election. We are the state is absolutely not concerned with the election of APSU, this present. But in future also, there may arise this sort of difficulties, law and order problem. So
At the time of final hearing.
yes, my lord. That's why that there is a live issue still. Even if the election is complete, results are declared, but the live issue still remains. That is the safety and law and order problem within the state. That issue will still remain.
Okay. You have filed your affidavit, yeah?
We have filed our status report with regard to what we have done to control the law and order situation.
Mr. Kato Learned, counsel for the respondent number so submits that he has already filed affidavit in opposition. And Mr. Ratan Learned, additional AG also submits that he has already filed affidavit in opposition.
We have filed status report.
However, Mr. M.K. Chaudhary Learned, counsel for the petitioner submits that he will file a response to the affidavit in opposition filed by the respondents, and he applies for granting him few days to file his response, and he also submits that till final hearing and disposal of the matter, the interim order passed earlier may be continued. Mr. Kato Learned, counsel for the respondent number so and so, however, submits that the voting process is started from today, and the respondents are not sure when the entire process will be completed. It may take from 5 days to 1 week. 5 days to 1 week. And he also raised the question of maintainability of this petition, as the petitioner who has instituted this PIL is neither a member of the student community nor
contesting in the election.
Nor he has contesting in the election. However, taking note of the submission of learned counsel for both the parties, it is provided that registrar lists the matter on 2nd of April, on which an endeavor will be made to finally hear and dispose of this petition. Until then, interim order passed earlier shall continue.
My submission is not only taking the interested party. This is a student organization. The non-registered student organization. That protection is also there.
That
protection. We have raised the objection not only to the extent of the status of the petitioner, but other aspects like maintainability on the
No, this is not a final order. We are postponing the matter till 2nd of April. On that day, you make contention.
Another area, we may be allowed to file additional affidavit to reinforce the records on the court. We may be allowed to file additional affidavit.
Mr. Kato also submits that he may be permitted to file an additional affidavit to bring on record the status of the election process. Okay, fair allowed. List the matter on 2nd of April.
Highly obliged, ma'am.
Yes.
Number 5 maybe I don't, because leading counsel is other state.
Who is the leading counsel?
Yeah, you get his file letter application.
Udeka. Mr. Your name, please?
Teacher. Another.
P. Sir, learned counsel for the petitioner submits that conducting counsel, Mr.
2 week time.
Conducting counsel, Mr. Udeka is out of station, and he pressed for listing the matter after 2 weeks. You are the respondent.
Yes, respondent number 4.
Mr. Your name, please?
Tarkama.
Learned counsel for the respondent number 4 submits that he has no objection. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that recessal is the matter after 2 weeks.
Thank you.
Is there any interim order? No. Is there any interim order? No. Okay. Okay.
Yes.
Yes. Next.
May I please, my I beg to item number 15 on behalf of Mr. Tony Patel. I've taken consent from all the parties that the matter may be posted on 1st of April for final disposal. This is a transfer and posting matter. So there's an interim order. 1st of April for endeavor.
Okay, Mr. Your name, please?
HP Jha.
Learned counsel appearing on behalf of Mr. T. Partin, learned conducting counsel for the petitioner with consent from the other side. Press for listing the matter on 1st of April. Where allowed, recessal is the matter on 1st of April. And on that day, an endeavor will be made to finally hear and dispose of this matter. Interim order pass earlier shall continue.
Highly.
Obliged.
Yes. I take the mention, I think we were 10. With the consent of the other person. Very on behalf of Mr. Epale.
Your name, please? Your name? Learned counsel appearing on behalf of Mr. L. Parme, learned conducting counsel for the petitioner. With consent from the other side, you inform the other side. Press for listing the matter after 3 weeks. They are allowed.
My lordship, I have this morning I have filed one WPC. Lordship, matter may be kindly taken up as in an unlisted matter, lordship.
When?
Lordship, it's a service matter.
When?
Transfer and posting matter, lordship. That is the today, lordship itself.
Today?
Yes.
Okay.
Obliged.
May I beg to mention item number 17. Lordship, we were supposed to take and we were supposed to object the IA.
File objection in the IA.
Yes, Lordship.
Okay.
So grant us 2 weeks of time.
Your name, please? Your name, please?
W. Wangsa.
W. Wangsa, learned counsel for the respondent. Or
Respondent, yes.
respondent.
Respondent number 3.
Respondent number 3 submits that he may be granted 2 weeks time to file objection in the IA. Who is for the applicant then?
I have taken the consent.
With consent from the other side, press for listing the matter after 2 weeks so as to enable him to file the objection. Parallel, this is a list the matter after 2 weeks. Okay. When?
Item 7.
The tender matter. Tomorrow is going to be filed. Because I am not able to participate in the tender process.
Okay.
All right.
Mention one unlisted litigation. Tender.
What matter?
Tender.
Tender matter. Okay.
Item number 1 to 3.
My lord, can we pass over for timing? The leading question is on the way.
Okay.
Item number 1, 2, and 3, 4.
Okay.
4 also.
4 also.
Item number 6.
My lord, I'm praying for Meter may be hard today.
Mr.
Odugong.
O. Dungan, learned counsel for the petitioner. With consent from the other side, as for adjournment of the matter.
No, my lord. Meter may be hard, my lord. Today, my
Record was called for, as in record is there.
Record was called for. Okay. Record received.
Yes. This is regarding pension matter.
For this person, my lord.
Yes.
My lord, petitioner late husband was working since 1976 as a casual labor till 2008.
Since 1977.
76
76.
as a casual labor till 2008. And my lord,
His service was not regularized.
regularized, my lord.
Regularized.
In 2008, my lord, his service has been permanently, given permanent appointment, my lord, 2008. And thereafter, his service, past service has been regularized with effect from 1983 to 2008.
Okay.
Regularizations.
Thereafter?
Thereafter, when he was regularized in 2008, at that period of time, NPS has just came up, introduced. Thereafter, my lord, it was the main issue, my lord. Thereafter, he claimed for the family pension, my lord. And the respondent is rejecting his family pensions. Department has, my lord, department has regularized since 1983 to 2008.
And
with
when
effect
the
from
new pension scheme came to force?
as a sweeper, my lord.
No. When the new pension scheme came into force?
1st January 2008.
2008.
8.
And his service was regularized in the year 2008.
8 in the month of uh, 26 November 2008. He was regularized.
26 November 2008.
8.
His service was regularized.
Given a permanent appointment. Appointment order is there.
Okay.
It is appointment order. A regulation letter has been issued in the year 2018, actually. Regulations, past regulation, his past service period of service has been regularized in 2018. After many letter has been conveyed to the higher authority, thereafter they regularize.
No. On 26/11/2018, he was
Regularized.
regularized.
His past service has been regularized. There is two thing. 2008, his service has been given a permanent appointment, but his past service has been regularized in 2018. Actually,
Where is the impugn order?
my lord, impugn order. My lord, page 46. In page 46, from the paragraph 1, it is clearly mentioned in the appointment law order dated late Ram Bahadur Bujal was engaged as a casual sweeper with effect from 1983 to the 25 November 2018 or 2008. Sorry, by order number RWC this and dated 8 August 2018. But the provisions were given benefit of the pension, family pension, and creating of 50% casual service to the length of the qualifying service has stopped with introduction of NPS with effect from 01/01/2008 in Arunachal Pradesh by the order dated this 18 June 2018. So the instant case is neither eligible for the family pension nor provision for creating 50% of casual service into the total length of the qualifying service is available. So his total regular service come to the 8 years, 9 months, and 11 days only. And excess drawer of the debt gratuity to the tune of 1,74,000 due to the wrong calculation may please be recovered and deposited into the treasury under the. This is the impugn order. My lord, my case is, my lord, that my post has already been created in 2002, my lord. My junior has been, when post has been created, my junior has been given regularized before the introduction of NPS. But in my case, though my post is created in 2002, but I have been appointed, I have been given the regular after the introduction of NPS. My lord, I file a additional affidavit.
Where is the document to show that your post was created in the year 2002?
My lord, page 110. Page 110. In pursuance of the Honorable High Court order dated order on 5/06/2003 in WPC 066/2001 and other writ petition filed by the worker, casual worker charge, casual worker, sanction is hereby accorded to the creation of 153 posts of the work charge, regular posts under the Rural Work Department as indicated below. I don't have a that order, High Court order, but based on this High Court order, this posts were created in 2001 or 2003, sorry. Thereafter, my lord, another page, my lord. 112.
No, no.
102.
Merely because some posts have been sanctioned,
Yes.
you cannot claim to be regular.
My lord, I will show my, I will show my lord, on which, based on this order, my regularization has been given, my lord. Oh, my lord,
What
my
is the
see,
regularization order?
regularization, my lord. 106, my lord. Page 106. In pursuance of the government order number RWD, sec 18/2002, dated 16/12/2003. This order, my lord. Based on this order, my lord. Based on this order, my regulation has been given. My lord may see where is this order, my lord. My lord, 110, my lord, page. This is a type copy, and this on this order, my lord, my appointment has been given. That's why I'm claiming 2003. Process already been created in 2003. And my lord, section is already been created in 2003, and my appointment has been given in 2008. Whereas my junior has already been given the appointment based on this order, sanction order. My junior appointment, my lord, may kindly see.
This page number 107 is the regularization of your junior.
Yes, my lord. His schedule labor with effect from 13/3/1987, whereas my service is with effect from 1983, my lord. And my lord, I have subscribed the GPF, my lord. GPF is a scheme which is related to the all pension scheme, my lord. It is not the scheme related to the NPS, my lord. So I've been allowed, and I have been deployed annually every year of my GPF fund. Thereafter, they have also paid me of GPF after my husband death. They have also sanctioned for the GPF amount, my lord. That means they have accepted that I come under the all pension scheme, my lord.
Who accepted?
My lord.
Who had accepted?
My lord, after GPF is related to the all scheme, all scheme, all pension, pension scheme, my lord. GPF is related to the all pension scheme, my lord. And this has been allowed me, my lord, allotted to me, my lord. That means department and government has accepted me as an eligible candidate for the all.
Maybe, but you say your service has been regularized in the month of November 2008,
my lord,
right?
My lord.
And a new pension scheme came into force with effect from 1/1/2008.
Yes, my lord.
So definitely your case is not covered under the old pension scheme.
My lord, sanction, my lord. Sanction has already been
Post is created, but can you claim right from the date of creation of the post? Yes, Mr. Tarak, what is your stand?
My lord, from the record, it reveals that there is contradictory statement given by the earlier officers. In the order dated 26 November 2008, this is his temporary regularization. Then here in this order, it clearly specified that he will not entitle for pension since order has been passed.
Where is that order? Page number?
Page 33 of the writ petition and relay type copy is page 35.
33.
This is 20 November 2008. Serial number, condition number 3. The CCS pension benefit of 1972 as well as allied benefit not applicable to the appointee in presence of Development Commissioner Finance Government of Arunachal Pradesh order number such and such 2007. As per this order, he is not entitled for pensions. But subsequently another officer has passed regularizing his temporary regularization. That is page 37 of the writ petition. Here again, it has been that the incumbent will be eligible for pensionary benefit as envisaged under CPWD manual, such and such, in this behalf, with effect from the date of regularization, but without area benefits. So this part I sought clarifications, but the present officer also they could not answer. This is the problem.
My lord, it is the mistake of the actually department. I had
as per
ought to be appointed. Given appointment before the introduction of the NPS.
Circular order dated 17/11/2007. He is no more entitled for pension.
Since
NPS implemented.
But as per this order, his service as casual sweeper is regularized with effect from 21st of October 1983 to 25th of
that is in the
November 2008.
Yes.
An incumbent will also eligible for pension benefit.
So if his service is regularized with effect from 21st of October 1983,
then
he will entitle.
Yes. Whether this order supersede earlier order dated 2008 or not, that also not clearly mentioned.
Where is the earlier order?
No, this page 35, my lord.
Page 35.
Yes. On recommendation of Departmental Promotion Selection Committee, Sri Ram such and such casual staff plus other elements and concession admissible time to time. This is promotion. Here, serial number 3 is clearly mentioned. The CC pension benefit of 1970 as well as allied benefit not applicable to the appointee in presence of Development Commissioner, Commissioner Finance Government of Arunachal Pradesh order number such as dated 17/11/2007.
No, this is appointment letter. Is appointed. Page number 33.
Yes.
Appointed to the post of sweeper.
Hmm.
Then this is a regularization.
Regularize.
And regularization is with effect from 21st of October 1983.
To if it is this order, then he is entitled.
He is entitled.
Then this order is as per this order.
Hmm. So there is no conflict in these two orders. One is appointment order and the other is regularization order. Regularization in respect of his past service.
So my lord, as per Director Pension and Audit letter, they have also confusion on this part. Page 43, 46 of writ petition.
Page 46.
Their query is here.
While passing this order, page number 47, they have not taken into account this page number 37.
Page 37.
Right?
'83. Period they have mentioned, but last part they have not mentioned.
And this amount they were not supposed to recover from him because it is an amount, excess withdrawal amount, in view of the decision of Supreme Court in Rafiq Masih's case. He is a Group D employee.
Yes.
That decision is available with you.
No, my lord, I have not.
No. Rafiq Masih's decision. That is the this amount was deducted or this was recovered from him? This amount?
I'm not inquired about this.
It was just a suggestion, I think, Your Worship. May please be recovered and deposited into treasury under proper head account as per this order. Your Worship, after the issuance of this order, Your Worship, we have sent two reminders to the department itself. The audit and pension. Then two reminders to the department regarding clarification of the service dictionary. For resubmission of his service entry and all. It's in our affidavit, Your Worship, page number 78 and 79.
Page number?
78 and 79.
Page number 78, 79. Yes.
It's one of 9 February 2000.
Resubmission of pension papers.
Yes, Your Worship. And the second one is of 26th May 2022.
And they have not submitted it thereafter.
Yes, Your Lordship. But the latest instruction, I don't have it.
Yes, submit kit.
What is the EVO for the pension and audit?
Yes, sir.
What is the extent of the department?
Your Lordship, because we are calculating is regularization from the November of 2008, Your Lordship. That's why we have rejected the old pension scheme.
No, while you have rejected his claim, whether the letter of the executive engineer was taken note of?
My lord,
In that, Your Lordship, we are silent, Your Lordship.
Hmm?
In that, we are
Pardon?
my lord, page 43, letter of the executive. When inquiry regarding inquiry, he has answered the inquiry, my lord. Direct pension director has inquired about the regarding his pension, whether he is eligible for the pension or not.
Mm.
That has been answered by the executive engineering. Page
Where?
number 43, my lord.
Page 43.
Of the petition?
Yes, petition 43. That has been answered, my lord.
Mr. Tarak
Yes.
and Mr. Riam also.
Yes,
You
sir.
see, this is the decision. Here, Supreme Court has stated that recovery from employees belonging to class 3 and class 4 service or group C and group D service is not permissible.
Yes, yes, Your Lordship.
So he is a group D employee.
Yes.
You see.
I think the recovery is not yet done, I think.
Not yet done.
There is no instruction. I think it's not yet done. In page 33, type copy 44 also, executive has admit that he is entitled.
Page number?
43.
43, sorry. The type copy is 44.
Yes.
There's that is serial number 2. As per regularized each service such and such,
Incumbent is entitled to
get
get benefit.
That means
So, what to do? We set aside the order, a letter of the accounts department, audit and finance,
Yes, sir.
audit and pension department, and they will consider his case in the light of this page number 44 and page number 37, 37 and 44.
Yes, sure. That can be done. Your Lordship. Because in our affidavit also we are silent about this one. 19 June 2019
Pardon?
letter year. In our affidavit we are silent with regard to Annexure 10, page number 43, Your Lordship. The clarification given by the executive engineer.
Hmm. So this recovery is also not permissible in view of that decision.
Yes, Your Lordship.
That decision. heard Mr. Dungan, learned counsel for the petitioner, Mr. Tarak, learned standing counsel for the respondent in
2, 4, and 5.
respondent in Rural Work Department, Govt of Arunachal Pradesh, being respondent number 2, 3, 4,
2, 4, and 5.
2, 4,
4
and
and
5.
5, yes.
2, 4, and 5, and Mr. Riam for the respondent number 1 and 2.
1 and 3.
1 and 3. 1 and 3. In this petition, under Article 226 of the Constitution of India, the petitioner has prayed for the petitioner has challenged the letter number PEN stroke AP stroke 31472 stroke 19-20 stroke 302 stroke 907 09 dated 6/9/2019, issued by the Director of Audit and Pension. And also to issue direction to the respondent authorities to grant the petitioner pensionary benefit from old pension scheme. It is to be noted here that by the impugn letter dated 6/9/2019, the Director of Audit and Pension being respondent number 3 has dismissed the claim of the petitioner. Mr. Dungan, learned counsel for the petitioner, submits that the husband of the petitioner was initially appointed as ALC at Pasighat in the office of the Additional Deputy Commissioner by order number P-6000 dated 1/12/1976. Thereafter, he was transferred to Nari by order number P-6010/131 dated 17/1/1977. And thereafter, again he was appointed as Sokidar of Raksin Rest House by order number RN/17/87-88 dated 19/9/1987. And there he served for a period of 2 years as Sokidar, and thereafter again he was transferred to Pasighat. And thereafter again transferred back to Raksin. In the year 1989, and he had been placed under disposal of RWD Department Raskin by memo number RNP-1/89 dated 1/8/1989. And since then, the husband of the petitioner was working as Sokidar. And also, in addition to the same, he worked as sweeper. In the rest house of Ruksin. Sorry. The learned counsel for the petitioner further submits that the Departmental Promotion Committee has considered the case of the petitioner and considered the case of the husband of the petitioner, late husband of the petitioner, and recommended his name for appointment to the post of sweeper in the year 2008. And thereafter, her husband was appointed to the post of sweeper by order number RWD/ESWT-239/05 dated 26/11/2008. And he served the department as a regular and temporary employee for 32 years. It is further pointed out that many juniors to the husband of the petitioner were regularized before introduction of the new pension scheme, but the case of the petitioner was given. No, but the service of the husband of the petitioner was given regular appointment after introduction of NPS. It is the further submission of the learned counsel for the petitioner that the respondent number 5 had forwarded the service book and pension paper of her deceased husband to the Director Audit and Pension. And in response to the letter number PRWD/PF-163/2008 dated 19/6/2019 has issued the Director Audit and Pension. It is also the submission of the learned counsel for the petitioner that the service of the husband of the petitioner had been regularized from his initial date of joining as casual sweeper with effect from 21/10/1983 to 25/11/2008 by order number RWC/CORD/ESWT/WC within bracket R stroke 410/2016/3190-93 dated 8/8/2018, and the said letter is enclosed with the petition as annexer. As annexer 7 at page number 37. Page number 37. And contrary to the above mentioned date of regularization, the executive engineer Pasighat has written a letter to the Director Audit and Pension by letter number PRWD-PF-163/2008-2008, which is enclosed with the petition as annexer 10 at page number 43, put in bracket, type copy at page number 44. That the service of the petitioner's late husband has been regularized by government late order number RWD/SECWT/18/2002 dated 16/12/2003, and necessary entries has been made in this service book by page number 14 as per GOPT appointment number 20/12/2008 RWD/ESTT-239 dated 26/11/2008. And his service has been regularized in the year 2003 as per GOVT order number RWD/SCCTT/18/2002 dated 16/12/2003. And in spite of the aforementioned letter of the executive engineer, the pension papers of the petitioner's husband has not been processed, and consequently, she has been deprived of the benefit of the same. And being agreed, the petitioner approached this court by filing the present petition. The respondent authorities have filed their affidavit in opposition. Affidavit in opposition, denying the statement and averment made by the petitioner in the writ petition. Mr. J. Tarak, learned counsel for the standing counsel for the respondent number so and so. Referring to the order dated 26 November 2008 at page number 33 of the petition, submits that his service was regularized. The husband of the petitioner was appointed to the post of sweeper with effect from 28/11/2008. However, referring to the page number 37 and also 44, he submits that in view of the regularization of the service of the husband of the petitioner with effect from 21/10/1983 to 25/11/2008, and also in view of the letter of the executive engineer dated 19th of June 2019, especially as per clause 2, the husband of the petitioner is entitled to regular pension. And when he asks for the requisite information from the department could not furnish any plausible answer in respect of the page number 44, Mr. Tarak. The department could not say anything in respect of this page number 44.
44.
Page number 44.
Not 44. The earlier which my lord had clarified that.
37.
Yeah, 37, and there is another order that
37 and 44.
44, department has said nothing.
In respect of 37.
44. This, there, not this.
37.
Yes,
Only 37.
37, yes.
Okay, 37. Page number 37. Mr. Ram Learned, standing on a learned government advocate for the respondent number so and so, also subscribe the submission of Mr. Tarak Learned, standing counsel for the respondent number so and so. Having heard the submission of learned counsel for both the parties, this court has carefully gone through the petition and the documents placed on record, and also perused the letter dated 26th of November. No. Impugned letter dated. Uh, 6/9/2019. Memo number PEN/AP stroke 31072/19-20 stroke 302 stroke 907-0909. And it appears that the husband of the petitioner, late husband of the petitioner, was appointed to the post of sweeper on temporary capacity in the scale of pay of rupees. No. Full quiz, I don't know. Also gone through the impugned letter, which is annexed with the petition as page number 47. And for ready reference, the same is extracted here in below, page number 47, 14. And it appears that there are two clauses in the said order, and the clause 1 provides that the new pension scheme came into force with effect from 1/1/2008 in Arunachal Pradesh. And the service of the petitioner, and the petitioner was engaged as casual sweeper by order dated 25/11/2008. And as such, he is neither eligible for family pension nor provision for crediting 50% of casual service into the total length of qualifying service is available. And clause number 2 indicates that total regular service comes to 8 years, 9 months, and 11 days. And the excess drawal of debt gratuity to the tune of rupees 1,74,050 rupees due to the wrong calculation may be recovered and deposited into treasury under the proper head of account. And it appears that while the aforementioned letter was issued on 6/9/2019, returning the pension papers and service book of the late husband of the petitioner, the authority has failed to take note of the order dated 26th of June 2016, whereby Annexer 7 at page number 37, whereby the past service of the petitioner was regularized from the initial date of his joining as casual sweeper with effect from 21/10/1983 to 25/11/2008. And also the letter of the executive engineer dated 19th of June 2019, whereby in clause number 2, it has been clarified that as per regularized Completion of his service by order number RWD stroke SCC T stroke 2018 stroke 18-2002 dated 16/12/2003. The incumbent is entitled to get the benefit for pension. Benefit for pension. And further, it appears that in the impugned letter dated 6/9/2019, the Director, Audit and Pension has directed for recovery of a sum of rupees 1,74,050,000. So no, 74,000 and rupees and 50 as excess drawal of death gratuity due to wrong calculation. But the same is impermissible in view of the law, in view of the decision of Honorable Supreme Court in the case of State of Punjab versus Rafiq Masis within bracket White Rose. And under the above mentioned facts and circumstances, and also as agreed upon by learned counsel for both the parties, the impugned letter of the Director of Audit and Pension dated 6/9/2019 stands set aside and quashed. Now, the matter is remanded to the Director of Audit and Pension, Dr. Varunachal Pradesh, to reconsider, to process the pension papers of the petitioner in the light of the order dated 26 of June 2018, Annexure 7, and also in the light of the letter of the Executive Engineer dated 19th of June 2019, especially at clause number 2. Clause number 2. And pass necessary order in respect of entitlement of regular pension by the late husband of the petitioner. And the aforementioned exercise has to be carried out within a period of 3 months, from the date of receipt of certified copy of this order. The petitioner shall obtain a certified copy of this order and place the same before the respondent number 3 within a period of 1 week from today.
My lord, just a clarification, my lord. In 2022, same line, director has, the audit has also issued a notice letter in the same query, regarding the same query. That may be also suggested, my lord.
Is it part of the record?
Yes, my lord. Page 53, my lord. I forgot to mention this order, my lord. Page 53. Joint director, or it is issued by the joint director.
So not necessary.
Okay.
We have already issued direction to process his pension paper.
Obliged.
No, in terms of a this petition instance.
Item number 7.
Replacement. My lord, Lordship has directed to produce the CTC copy of charge sheet on last occasions, and I file for additional affidavit. Additional affidavit, Lordship. The question is not about section 354, Lordship. Is in this case, page 123 in additional affidavit. (123).
Record earlier case record.
Pardon?
Case record. Case record.
Which one?
Last previous one. Record that one. Yes.
Please, Lord. Page 121, madam. Additional affidavit. Why the section 384 was struck out, Lordship? Additional affidavit, Lord.
Hmm.
121. Here, Lordship, the learned FIFI has submitted before the lower court that section 354 is not affected in this case. That's why it was struck out. That's why section 419 and 506/34 was referred for CC on. My lord. That's why the 384 is dropped only. The offense of section 419 IPC and 506 is affected. This is, my lord, clarification to why the 384 was dropped.
What is that order? By which this 384 was dropped?
The order is page 121.
125.
121.
121.
1. Yeah, it is, my lord.
Yes.
Today it speaks for appearance. Both accused Mr. Raising Talo and Kadum Jamo are present along with learned PTC Mr. T. Taki. Learned PP Mr. B. Lego is present. Learned APP submit that there is prima facie matters only for offense of section 419 of 506/34 IPC against both accused and is affected against them. Frame for framing charge. No material for offense of section 384 is found against the accused person. On other hand, learned PDC submitted both the offense are compoundable and pray for allowing the informant, Mr. Marcel Jarang, who is present, to compound the case. Third, learned counsel, the matter recorded. This court inclined to concur with the submission made by learned APP. The offense of section 384 is dropped. This is the case, my lord. Now the already we have submitted my lord, the termination was done on arbitrary manner, and no notice was issued to the petitioner. My lord, in support of my submission, I would like to place some judgment. My Lord, kindly on page 11, paragraph 13. This is exactly applicable to my case, my Lord. Paragraph 13. What emerged from the my Lord? What emerged from the exposition laid down by this court is that mere suppression of material false information, regardless of fact, whether there is conviction or acquittal, has been recorded. The employee requisite is not to be discharged, terminated axiomatically from service by a stroke of fact. At the same time, the effect of suppression of materials, false information involving in the criminal case, if any, is left for employer to consider all the relevant facts and circumstances available as to antecedents and keeping in view the objective criteria and the relevant service rules into consideration while taking appropriate decision regarding continuance suitability of employee into service. What being noticed by this court is that mere suppression of materials or false information in given case does not mean that employee can be arbitrarily discharged or terminate the employee from service. And in, Your Honor, in After Singh versus Union of India, one reference is here, page 8, my lord. After Singh, page 8 of same judgment. Yes, in that is the operative part of page 35. After Singh versus Union of India. Suppression of material information presuppose that what is suppressed, that matter not even technical or tribal matter. The employer has to act on due consideration of rules, public instruction, if any, in exercise of power in order to cancel candidature or for terminating the service of employees. Though a person who has suppressed the material information cannot claim unfettered right for appointment or continuity in service, but has a right not to be dealt with arbitrarily, and exercise of power has to be in reasonable manner with objective having due regard to pay objectives. My lord, this case is applicable in my case because the petitioner was in probation and he was terminated arbitrarily, and the Supreme Apex Court has dismissed the writ petition order passed by the High Court.
Yes, Mr. Liam.
Yes, Your Lordship. Your Lordship, if we see the attestation form, Your Lordship, of the petitioner, Your Lordship, it's
Page
in
number
91 of our affidavit, Your Lordship.
91.
I'm sorry, it starts from 89, Your Lordship, Annexure 3.
Start from page number
89, Your Lordship.
89.
If Your Lordship may turn to page 91.
Attestation form 94.
Yes, Your Lordship.
Yes.
Starts from 89. Your Lordship may kindly turn to page 91, Your Lordship. Column 11, Your Lordship. It's in second column, Your Lordship. 11. 11A. May I, Your Lordship? Have you ever been arrested, prosecuted, kept under detention, or bound down / fined, convicted by a court of law for any offense, or debarred, disqualified by any public service commission from appearing at its examination selection, or debarred from taking any examination restricted by any university or any other education authority institution? He has answered no, Your Lordship. And if we see the date, Your Lordship, at the bottom, Your Lordship.
Mm.
It's 18 to 24, Your Lordship.
Page number?
Same page, Your Lordship.
Okay.
In the bottom, Your Lordship. Date is 18 to 24.
Yes.
And now if we come to the additional affidavit, Your Lordship, which is at 120, Your Lordship. Just now he has read it, Your Lordship. Additional affidavit, Your Lordship. Page
Filed by
number
the petitioner.
122. 120, Your Lordship.
Yes.
It is dated 6/6/24, Your Lordship.
Mm.
It means he was well aware of the case. Despite that, he has submitted no, Your Lordship.
Mm.
There is clearly separation of facts, Your Lordship.
Mm.
There is our only case, Your Lordship. Even he had the knowledge, but then again, he has answered no in that column, Your Lordship. And since he is serving in a police force, Your Lordship, that is not at all accepted, Your Lordship.
Okay. Heard Mr. T. Takil, learned counsel for the petitioner, and also heard Mr. William, learned counsel for the learned government advocate for the state respondent. Argument concluded, order reserved.
Item number 8.
Yeah, please, Your Lordship. Here I have challenged the suspension order, Your Lordship, and subsequent review order also, Your Lordship.
Subsequent review order.
Review order also.
On what is the ground for?
Lordship, the
Subsequent
second review which was conducted was belatedly after a lapse of 22 days delay.
After the lapse of 22 days.
Yes, Your Lordship. That is,
tell me when he was suspended.
Lordship. He was suspended on 31/2025.
(31 2025).
And thereafter, first review was conducted on 23rd April 2025.
First review on
23 April 2025. And
second review
was 18th November 2025, which review conducted is after a lapse of 22 days delay, Your Lordship, which was expired on 27/10/2025.
After lapse of
22 days delay.
Expired on
27/10/2025. Since the order dated 18 November 2025, the review was conducted on 18/11/2025. Second review was conducted on 18/11/2025, whereas it was expired on 27/10/2025. So therefore, there is a delay of 22 days delay. Therefore, is not sustainable under Rule 10(6) of the CCA Rule 1965, Your Lordship.
Rule 10?
10(6) of the CCA Rule 1965. As because such reviews mandatory required to conduct before expiry, failing which the suspension lapses automatically, Your Lordship. Lordship
Okay.
knows, Your Lordship, already. And
Whether that rule is part of this record? You have enclosed the rule?
no, Lordship, I have not enclosed that. Is not.
You have quoted here in the petition?
Yes,
Not quoted.
I have somewhere. Yes, in paragraph 5.
Paragraph 9.
Lordship, I will. Right. Yes, Lordship, in paragraph 16 also, Lordship. In paragraph 16, specifically, I have stated. Review under Rule 10(6) of the CCS Rule 1965, while the suspension may be permissible during the pendency of the disciplinary proceeding. I have cited the Honorable Supreme Court judgment also of the Ajay Kumar Chaudhary. And I have specifically stated also regarding 22 days delay also in that. And I have relied some judgments, Your Lordship, or should I, in 2015-7 SCC, page 291, para 21, Your Lordship. And I have also relied the judgment of.
No. Are you furnishing the copy to?
Lordship, I have already. Ajay Kumar.
When you have furnished the list?
I have
During the court hours only. Actually, I used to mention all the advocates that before the court, during the court hours, they have given me the list. They should have given me early in the morning.
I will also furnish, Your Lordship.
You, Mr. Singh,
Lordship.
you do one thing. You obtain this Xerox copy of all those decisions and furnish it to the court master.
Lordship, I am having one extra copy, Your Lordship. All the judgment.
But have you furnished the list of citation to the council for the response?
During the motion time, I have furnished, Your Lordship, the copy. List of books.
Mr. Tago?
My lord.
What is the extent of the department?
My lord, department, my lord, of course, due to administrative oversight, my lord, there's a lapses. The delay part is, my lord, it's admitted.
So
fact.
you are admitting it.
My lord, 20
There is
days.
delay.
Yes, my lord. There's
No, the issue is whether on account of such delay and lapses on your part, the extension order can sustain?
my lord, my respectful submission, my lord, it may not sustain.
May not.
Because, yes, may not sustain. Because once it is lapses, my lord, that the continuity is break, my lord, then automatically, my lord, subsequent consequential action, my lord, it is not sustainable. As per my understanding.
Then why don't you suggest them to revoke the suspension order?
My lord, that part, my lord, I don't know, my lord, this how the department is doing this. Not only this, but
Mr. Tagum, you see, what is the purpose of keeping one standing counsel for the department?
my lord, that is
to advise them.
My lord, I do agree, my lord. This is my lord. But in
I've seen not only in this department or in other department, I've seen my love, in such cases, my love, there's appears to be my love, there's a such lapses, my love. They coming to the court only through the court they want that this thing, my lord. I don't know how this thing, but in this case, my lord, they have admitted in the file noting that there's some administrative oversight, my lord. It was put up. The file was put up for review after 3 days, my lord. 27 October of 2025, it expires, and on 30 October it was put up. And subsequently, in the process, while obtaining entire constituting the review committee, it took 22 days, my lord. Finally, at 22 days, my lord, this review was conducted.
So in their affidavit, it's admitted. In page 86 of the affidavit in opposition, Lordship, in the file noting also, the review committee has recommended the extension of another 180 days with effect from 1/5/25. The extended period got expired on 27/10/2025. As per Rule 10.
Okay.
Lordship.
Okay. Heard. Mr. A.K. Singh, learned counsel for the petitioner. Mr. T. Tagam, learned standing counsel for the education department.
Yes, my lord.
Being respondent number
2, my lord.
Respondent number 2, and Mr. Riam for respondent number
1.
Respondent number 1. In this petition under Article 226 of the Constitution of India, the petitioner has challenged the order. Challenge the suspension order number SEDN-12011/1/2024 dated 30/1/2025, and also
23rd
the
April.
order dated 23rd April 2025, number SEDN-12011/1/22 299, and also the order dated 18/11/2025 issued under memo number SEDN-12011/1/2024/839. 839. It is to be noted here that by the impugned order dated 30/1/2025, the Commissioner, which indicated Education, Government of Arunachal Pradesh, has placed the petitioner under suspension, and by the impugned order dated 23rd/4/2025, the Commissioner, Education, Government of Arunachal Pradesh, has extended the suspension period of petitioner for further period of 180 days with effect from 1/5/2025 pursuant to the recommendation of the suspension review committee, and by order dated 18/11/2025, the Commissioner Education, Government of Arunachal Pradesh, has extended the suspension period of the petitioner for further period of
180 days.
180 days.
180 days. No, the last one.
Last one, 180 days.
180
with
days.
effect from 28th October.
Mr. Singh, learned counsel for the petitioner, submits that the petitioner was holding the post of Deputy Director of School Education in Anjao district.
Lordship.
And he was served a show cause notice on 30/5/2024, alleging irregularities in appointment. Thereafter, the petitioner has submitted his reply on 12/8/2024, denying the allegation. Thereafter, he was placed under suspension by impugn order dated 30/1/2025. And his headquarters is fixed at Itanagar during the period of suspension. Accordingly, the petitioner has reported on 17/2/2025, and he has been cooperating with the disciplinary authority. Mr. Singh, taking this court to the order passed by the Secretary, by the Commissioner Education, Govt of Arunachal Pradesh, Itanagar, dated 23rd of April 2025, which is annexed with the petition as annexer number 5 in page number 33, submits that by said order, suspension order of the petitioner was extended for a period of 180 days with effect from 1/5/2025. Further, he submits that the said 180 days expired on 27/10/2025. After the lapse of 22 days. 22 days. And since the respondent authorities have failed to review the suspension order and to extend the same within the period of 180 days, the impugn order by which his suspension period is extended for further period of 180 days by order dated 18th of November 2025, Annexure 6 at page number 36 of the petition, is illegal and arbitrary in view of the decision of Honorable Supreme Court in the case of Ajay Kumar Chaudhary versus Union of India, reported in 2015 7 SCC, page number 291, and also in view of the provision of Rule 10, which will make it 6 of the CCS, which will make it CCA Rule 1965. And in that view of the matter, the suspension order and also the extension order dated 18/11/2025 are required to be interfered with. Mr. Tagum Learned, standing counsel for the respondent number 1 or 2?
2, my lord.
Respondent number 2, referring to the affidavit in opposition, submits that due to administrative oversight, there was delay of 22 days in extension of in review
Reviewing and
extension of the suspension order.
One.
Suspension order. Having heard the submission of learned counsel for both the parties, this court has carefully gone to the petition and the documents placed on record and also perused the impugned suspension order dated 30/1/2025, the first review order dated 23rd/4/2025. Annexure 5 And also the second review order dated 18th of November 2025, Annexure 6 of the petition, and also carefully gone through the decision of Honorable Supreme Court in the case of Ajay Kumar Chaudhary, and also gone through the CCS rule. Also gone to the Rule 10 within bracket 6 of the CCS within bracket CCA Rule 1965. 65. In the case of Ajay Kumar Chaudhary within bracket Sopra, it is well settled that the suspension order has to be reviewed within the period of 180 days or 30 days.
Well, it is 90. In case of Ajay Kumar Chaudhary, it's a 90 days.
90 days.
First, the suspensions for within 90 days is to be reviewed.
90 days.
Thereafter, 180 days.
And thereafter, it has to be reviewed.
Yes.
Within the period of 180 days. 180 days. 180 days. And Rule 10.6 of the CCA, CCS within bracket CCA rule also provides the same. In the instant case, it appears that when the suspension order was passed on 30th/1/2025, the first review was held on 23rd 4/2025, and it was extended for a period of 180 days. And the second review was done on 18/11/2025, whereas the period of 180 days expired on 27/10/2025. The review was done after elapse of 22 days. 22 days. And in that view of the matter, the subsequent extension order dated 18th of November 2025 to the considered opinion of this court fails to withstand the legal scrutiny, and as such, the same stands set aside and quashed. And consequently, the suspension order of the petitioner dated 30th/1/2024 also stands set aside and quashed. The respondent authorities stands quashed in view of setting aside of the extension order dated 18 November 2025 and also the suspension order dated 30th/1/2024. Now, the respondent authority shall reinstate the petitioner and he may be posted in a different place if so advised. However, it is being clarified that the departmental proceeding initiated against the present petitioner shall continue, and the respondent shall take the same to a logical conclusion within a period of sort of fixed timeline. As soon as practicable. As soon as practicable.
Lordship reinstated and with all the consequential benefits, Your Lordship, that part.
The department have looked into
Because
it.
With all consequential
otherwise,
benefits. Consequential service benefit which he is legally entitled to.
Lordship.
Your Lordship, if I may, Your Lordship, in item number 7, I'd like to strike two judgments, Your Lordship. All right.
Okay.
Item number 9.
May I please, Your Lordship?
Yes,
Service upon respondent number 5 is still awaited, Your Lordship.
awaited.
Yes, Your Lordship. And respondent number 2 and 4 are yet to file their affidavit.
Okay. Heard, Mr. Your name, please?
M. Taso,
Learned counsel for the petitioner
on behalf of R. Soikia.
on behalf of,
R. Soikia.
appearing on behalf of Mr. R. Soikia, learned counsel for the petitioner. And Mr. Roton, you have for respondent number?
Yes.
One, two, and three.
1, 2, and 3.
Four.
One.
1, 2, 3, 4. Four.
The office note dated 25th of March 2026 indicates that neither ID card nor answer notice received in respect of respondent number 5. What to do? You want to take fresh system or will await service report?
We'll await service report.
Await.
Yes.
Okay. SSL list the matter after 2 weeks awaiting service report upon respondent number 5. The learned counsel for the petitioner has also pointed out that respondent number
2 and
who
4.
has not filed the affidavit in opposition,
2 and 4.
2 and 4
Yes,
have not filed their affidavit in opposition. Mr. Roton, you will file? You will be filing?
Yes, my Lord.
And
Well,
Mr.
for
Roton,
which,
learned.
is the deputy commissioner,
No, director,
director,
land management.
No, my Lord, 3 and 4. 3 and 4.
3 filed.
My Lord, then the 3 will cover. My Lord.
Deputy commissioner.
Yes, sir.
Okay.
2 and 4.
Mr. Roton submits that respondent number 2 and 3 will be filing the
My Lord,
affidavit in opposition.
yes.
And applies for listing the matter after 2 weeks. They are allowed? This is list the matter after 2 weeks.
My Lord, 3 has already filed.
3.
3 has filed.
3 years.
Only 2.
2, 1 file came.
No, only 3. Obliged.
Item number 11.
May it please, Your Honor.
Yes.
Your Honor, this matter has come for orders. Here I am praying for a 10 days time to file additional affidavit, Your Honor. Notice was issued on 15/5, but the state respondent, private respondent, sole respondent has not filed their written statement also. But here I am praying for 10 days time to file my additional affidavit. I want to bring one agreement to record. Appointment of Section 11 arbitration petition.
Mr. Mohanto, learned counsel for the petitioner. None appears for the respondent on call. The learned counsel for the petitioner submits that he may be permitted to file an additional affidavit to bring on record certain documents. They are allowed to list the matter after 10 days.
Yes, Your Lordship. Yes. Deeply aware. Deeply aware.
Item number 12.
Your Honor, Your Lordship, standing counsel Inter Pisa has to be here, Your Lordship. He has to furnish the status report. Some documents has to be, original documents has to be furnished, has to be placed before this honorable court.
He is in the other court.
He was
Okay,
available
okay.
outside.
Yes, next item.
Item number 13.
My please, Lordship. Lordship, I am praying for disposal of this matter. Lordship, this is, there was a village level cover. Cover was decided the case in favor of private respondent number 3. And accordingly, the present petitioner in terms of Assam Frontier Justice Regulation Act 1945. Earlier, appeal has to be filed before the Deputy Commissioner. So accordingly, it was filed appeal before the Deputy Commissioner. And thereafter, in the year 2021, the Arunachal Pradesh Civil Code Act came. And Act says that if the appeal which is pending before the Deputy Commissioner has to be, DC has to be, affiliate authority has to be disposed of the appeal within 1 year. But if they could not dispose of within 1 year, the appeal has to be transferred to the regular court, Lordship. Now, here in my case, Lordship, instead of transferring my appeal, they're passing an impugn order saying that you approach before the civil court. This is my case, Lordship. Lordship, the consequences
Instead of transferring the
my appeal, Lordship, which was pending.
Transferring the appeal,
Yes.
the Deputy Commissioner has
Directed me
disposed
to
of the matter.
Yes.
Directed you to approach the
civil court by filing title. Now the consequences will be, Lordship, if I file fresh appeal, then the limitation will apply. My appeal, statutory appeal will be deferred.
will apply, but this section 14 of the Limitation Act is there to take care of the same.
But that is, Lordship, only they are saying, may I take you to the impugn order, Lordship, the language, Lordship, page 55. It was only served by way of notice, Lordship, only. 55. Subject, Pape Rigom, this is the disputed land name, Lordship. Whereas the Pape Rigom Rangom land dispute, title suit between Srimati so-and-so, she is the petitioner, Lordship, and she is the respondent, and Sri Tajen Diru, petitioner before your Lordship, on behalf of Diru clan. 7 Tato has been affiliated in the court of the district magistrate, and as for the provisions of Arunachal Pradesh Civil Courts Act 21, Arunachal Pradesh Civil Courts Amendment Act 2022, and the Assam Frontier Administration of Justice Regulation 2023, the administrative officers are no longer the appellant authority in any civil or criminal matter. In the light of the above circumstances, you are to approach the appropriate court, that is the court of a civil judge, for early disposal of the case. Now, language of this impugn order, Lordship, now they are directing me to file a appeal before the appropriate authority. But Act says that, Lordship, if the Deputy Commissioner could not dispose of within 1 year, after coming into force of Arunachal Pradesh Civil Court Act, the Deputy Commissioner has to transfer the appeal petition to the appropriate civil judge. So in that case, Lordship may direct the Deputy Commissioner to quash this impugn order and direct the Deputy Commissioner for transferring of my appeal before appropriate civil judge. That is the ALO, Senior Division ALO. That is my prayer. And on last occasion, Senior Government Council has directed to take instruction from the Deputy Commissioner. So this case is waiting only for their instruction only.
Mr. Ratan, what instruction is available with you?
In fact, this is with regard to interpretation of that Civil Codes Act. Yes, it is the duty of the Deputy Commissioner to transfer it. If there he couldn't dispose of the appeal in that limited time frame. It was after the 2021
amendment
Act came into force. There was a grace period of 1 year to dispose of all the pending appeals which is pending before the Deputy Commissioner. If that 1 year has expired, then it is the Deputy Commissioner who has to transfer it to the appropriate civil court.
So in fact, this is not an order.
Yes, my lord. There can be two options. Either the Deputy Commissioner transfer it if this order is set aside, or my lord may observe that the limitation will not be if in the event the petitioner approaches the
civil court,
then the limitation will not be applied. Bar of limitation. In that manner, he can file an appropriate appeal also.
Press appeal.
Press appeal. By this, order, it seems that the Deputy Commissioner wants him to file a fresh appeal. What is pending there, he is not transferring it. Rather, the petitioner has to file a fresh appeal.
Okay. Heard. Mr. Lolan, learned counsel for the petitioner, and Mr. N. Roton, learned additional advocate general for the state respondent. In this petition under Article 226 of the Constitution of India, the petitioner has challenged the letter of the Deputy Commissioner, Siomi District, dated 10th of March 2025.
Yes.
Which is annexed with the petition as annexure number 6 at page number 55. 55. Is to be noted here that by impugn letter dated 10th of March 2026, the Deputy Commissioner Siomi District has directed the petitioner herein to approach appropriate civil court, that is the court of civil judge, for early disposal of the case. Early disposal of the case. Mr. Roton, no, Mr. Lolan, learned counsel for the petitioner, submits that in between the petitioner and respondent number 3, there was a land dispute in respect of a land called Ripe
Pape, PFE, Lordship. Pape Rangom.
But you have mentioned it as a Ripe Rangam.
Lordship, in impugn order, it is reflected as
Pape Rangam. Pape Rangam.
Yes, Lord.
Pape Rangam. At Siomi District, Tatu. Tatu. So, several initiative was taken to resolve the dispute amicably. The same failed to yield any result.
Lordship, Kaba was passed a decision on 3/10/2020, Annexure 1, Lordship.
Thereafter, as per order of the Additional Deputy Commissioner Tato dated 14/9/2020,
Yes, Lord.
the matter was referred to Kebang.
Yes, Lordship.
And accordingly, Kebang was constituted and a meeting of the Kebang was held on 3/2020.
Lords.
And in the said Kebang, without hearing the matter properly, the members, and without considering the land demarcation record, the Kebang in most illegal and arbitrary and biased manner passed the decision on 3/10/2020, thereby deciding the dispute of land in favor of the private respondent number 3.
Lords.
Mr. Lolan further submits that being aggrieved by the decision of Kebang dated 3/10/2020, the petitioner herein has preferred an appeal under section 46 of the Assam Frontier, within bracket, Administration of Justice Regulation 1945,
Lordship.
before the Deputy Commissioner Siomi District Tato on 18/10/2020.
Lords.
With a prayer for review of the Kebang decision dated 3/10/2020 by rescheduling a fresh hearing of the case by appointing a new Kebang body, supervisor and Kebang members. But even after receipt of the appeal, the Deputy Commissioner Siomi District Tato had failed to take up the appeal for hearing, and the same was kept pending for several years. And in the meantime, Arunachal Pradesh Civil Court Act 2021 and the Arunachal Pradesh Civil Code Amendment Act 2022 came into force. And the second proviso of subsection 3 to section 15 of the Arunachal Pradesh Civil Code Amendment Act 2022 provides that in case the Deputy Commissioner could not dispose of the pending appeal in their courts within 1 year from the date of commencement of Arunachal Pradesh Civil Code Act 2021, they shall transfer suspending appeal cases to the Court of Civil Judge Junior Division, the Court of Civil Judge Senior Division, the Court of Additional District Judge or the Court of District Judge, as the case may be, as per their territorial and pecuniary jurisdiction. Mr. Lowland further submits that thereafter the Deputy Commissioner, by impugn order dated 10/3/2025, impugn letter dated 10/3/2025, directed the parties to approach before the appropriate court, that is Court of Civil Judge, for early disposal of the case. Mr. Lowland submits that the petitioner herein has preferred the appeal before the Deputy Commissioner Xiaomi District on
1810 2020.
2020.
Lord, sir.
2020. And pending disposal of the said appeal before the Court of Learned District Judge, no, before the Court of Deputy Commissioner Xiaomi District, the Arunachal Pradesh Civil Court Act 2021 and also the Amendment Act 2022 came into force. And as per subsection 3 to section 15, if within a period of 1 year the Deputy Commissioner failed to dispose of the appeal, then he or she should transfer the same to the Court of Learned Civil Judge. But instead of transferring that case to the Court of Learned Civil Judge,
Lord, sir.
Yes. The Deputy Commissioner has simply directed the parties, directed the petitioner herein to approach the appropriate civil court. And as per tone and tenor of the aforementioned letter dated 10th of March 2025, the Deputy Commissioner means that a fresh appeal has to be filed before the Court of Learned Civil Judge. But in that event, the question of limitation will arise, and in that view of the matter, Mr. Lowland submits that this matter may be disposed of by setting aside the letter dated 10th of March 2025 and also by directing the Deputy Commissioner Xiaomi District to transfer the appeal, being appeal number.
Appeal number, Lordship, number has not been provided.
Then?
Only dated, Lordship. Appeal filed on that reflection of that and the name will sufficient, Lord, because
appeal filed by the present petitioner, namely Srimati
Tajendiru, Siri Tajendiru, Lord.
Okay, Sri Tajendiru.
Yes.
Dhiro on
18/10/2020.
18/10/2020. 18/10/2020.
Yes, Lord. So 18/10/2020. In respect of the disputed land, Lord, it will suffice.
In respect of the disputed land, namely Paperegom, between the petitioner and Srimati Yaing Kosang.
Yaing Kochung. Respondent number 3.
And the aforementioned exercise has to be carried out within a period of 2 weeks. From the 1 week from the date of receipt of certified copy of this order.
Lordship.
The petitioner shall obtain a certified copy of this order and place the same before the Deputy Commissioner Xiaomi District within a period of 1 week from today.
Yes, Lordship.
Obliged.
Deeply obliged.
Item number 14.
May I
My lord,
please-
my lord, item number 14, my lord, I have filed my affidavit today, my lord, for respondent number 16.
Respondent number
16, my lord.
16.
16. Wakalat
I am
nama and
appeal- I am appealing for respondent number 17 to 26. I have also filed the affidavit in opposition today, also raising the question of maintainability of the petition itself.
But I am appealing for respondent number 27.
I may pray that matter may be hard at length, matter because pleadings are from our side is complete. If they wish to file any reply, they may file me.
May I, my lords?
Yes.
My lord, you would kindly see the last order of my lords.
Mr. Counsel, you see the affidavit filed by Mr. Deepanging for the respondent number 16 is not available before this court right now.
Yes.
So perhaps we'll not be able to hear the matter today.
All right, in that case, may I request my lords to
Yes.
keep the matter convenient to my lords next week?
Next week. Okay. Then
Because there is
another
an
question
interim
will
prayer
arise.
which I am pressing, and there is an order dated 21st of October, which my lords had my lords observed that the interim prayer will be considered on the next date of hearing. So many next date of hearings have passed because of not filing of the my lord's response by the opposition party. So I'm only requesting in that context, only for the limited purpose of the interim prayer. If your lordship would have order dated 21st of October.
That's all right. Mr. Counsel, you say the affidavit is not available before this court.
No, I'm saying, my lords, keep it for next week. That's the request for the consideration of only the interim prayer next week.
Okay, all right.
My lord, this matter would
Mr.
require an
Yeah.
extensive hearing, my lord. May I pray, my lord?
But I would like to satisfy my lords that this matter on the interim prayer is covered by the Honorable Apex Court judgments, various judgments, which clearly direct that it is the duty of all the officials of the country to follow the law of the land, and that's all we are asking. And what we are asking in the interim prayer is only this, nothing else. Consider our representation.
Firstly, he has to satisfy whether writ petition itself is maintainable. Who is he, my lord? How he is agreed with the, my lord, the grant of the, my lord, SC certificate to a particular community, while none of the petitioners belong to that. Though one petitioner is there, but his, my lord, identity is also doubtful. Nothing has been placed on record. So the maintainability is the first thing, my lord, that has to be, my lord, decided in this case.
That aspect also has been decided
And
already.
the interim prayer is something, what the main prayer is for constituting a SIT, etc., for inquiring into the.
No, not at all. Not at all. Interim prayer is different than
grant of
main prayer.
interim prayer, the main relief would be granted. And when the question of maintainability has been raised, there has to be how they are the person agreed. That has to be established.
The issue of
In my
maintainability.
affidavit, I have already given, my lord, two inquiries. I think the government has also filed an, my lord, affidavit
Okay.
some inquiry.
Okay, Mr. Soikia, we will first hear on the point of maintainability of the
Yes,
petition.
exactly, my lord.
Thereafter,
Can
we'll
I
consider the
just say?
interim.
Can I just say this? The issue of maintainability has also been crystallized by the first order of this honorable court only. So that is not pending. They have not challenged that order. The issue of maintainability is only on two aspects: form and style. That is the order which has been passed long back. Nothing else. Everything else has been argued at the time of issuing notice only. So this issue
Can
also
you-
has been crystallized.
We were not
that-
hard at that time, my lord. We are not hard at that time. And the form
Okay,
also
finish.
includes
Finish.
whether it is
They
able to
already
be-
had the opportunity of challenging this
No,
order.
no, you tell
Which they
me.
not. This
By-
has attained
No,
finality.
no, Mr. Counsel, you tell me by which order the issue of maintainability was dealt with by this court?
Can I, on the 21st itself? There are only two aspects of the maintainability which were left open, and that is 21st of October 2025. I
My lord, we
pointed
are
that
also
out
challenging
on
the
the
issue of
last date
maintenance. We
also
have
to
just
my
recently
lord.
filed our affidavit. Just
Can
3
I
days back,
just
we have filed
make
our
my
affidavit.
submissions? If my learned friend will allow me to make my submissions, then he can. My lord has asked me a question. I'm answering that. This aspect I had argued on the last date of hearing also before my lords. I am reiterating that 21st of October.
No. Yes, in the penultimate paragraph, it has
Yes, my
been
lord.
recorded that this court also finds that the maintainability of the instant writ petition in its present form
and style
should be left open
for consideration. Thereafter, my lord passed an order on the last date of hearing. If my lord would see last 4 lines of my lord's order on the last date. However, I'm sorry, my lord. Para 2. It appears from the record that the notices issued to the respondent 5 and 27 have already been held to be duly served by the order dated so and so. Though Mr. So and so, learned counsel for the petitioner has prayed
No
for.
finding is recorded. No finding.
Can I just take my lords? My lords, kindly see. However, considering the fact that the question of maintainability of the instant petition in its present form and style has also been raised by the respondents. Nothing else. Now, if they are having some more legal advice in hindsight, that's a separate matter. But for the interim prayers, this cannot be made as a ground to just further delay the proceedings. My learned friend wishes to argue at length. I'm willing. But this should not be made a ground to postpone this very important issue. And what I am arguing, my lords, and I'll show my lords the judgments also, not today, because my lord is saying the affidavit is not before my lords. There are catena of judgments of Honorable Apex Court. If there is a direction of passed by a superior court, every institution in this country is bound by it. Whether I have filed a petition in its proper form or not even material. I have brought this to the notice of this honorable court. That is sufficient. Now, this honorable court can convert this. I am willing to convert this into any other form which my lords wishes. I have no objections to that. But to say that we will not follow. But what my learned friend wants to say this is that I don't want to follow Supreme Court's directions. That is contempt of court. Nothing.
I did not say it so. Have you heard?
This is
the
totally
saying that,
unnecessary, my lord.
you have
Totally
not done it.
unnecessary.
I told Supreme Court
Petitioners are arguing like this.
This is deliberate disregard.
Did you hear me saying so?
Mandatory directions of the
If you
Supreme
have not
Court.
heard, why you are uttering those words here?
Okay, please.
It's putting words into the London Senior Counsel's mouth. That's unfortunate. What is this?
So you see, in this petition, this issue of maintainability is still not taken care of.
I would say
And
that
once
it
you
has
file
been,
it
my
on
submission
next
is
week, we will hear it.
only two aspects. My submissions may be noted down. Two aspects have been left open. Rest all will be decided in the final stages.
My lord, if we file an affidavit today, supposing, raising some question of law, including maintainability, your lordship will decide whether to take it up or not. How can the learned friend say this at this moment?
Yes.
That
Very
all can be
unfortunate.
decided
What the London Senior
simultaneously.
Counsel's mouth.
It is
Yeah.
settled law. There is no
Please.
mandatory provision that this should be decided before that. It can be decided together.
You
also,
may
it will
say
be
so,
clear
we will
matter.
argue.
Mr. Counsel,
That's why you don't file time.
I am dictating the order.
Reply your time in time. No, that's why. That is exactly
No,
why, because
please,
you want to argue.
please.
You don't file your replies again and again and again on last opportunity given, then you file this reply. This is most unfortunate too.
Please.
My lord, just
And this is a tribal
Your
state.
your good name, please.
Mahmood Pracha, my
Your
lords.
good name, please.
Mahmood
Heard
Pracha.
Mr. Prasa, learned counsel for the petitioner. And Mr. Pizza Soikia, learned senior counsel, assisted by Mr. Soikia. You were assisted by
Lolan is
Mr.
there.
K. Lolan. Counsel for the respondent number. You are for respondent number 17 to 26. 17 to 26. And you for?
Respondent number 28.
28. Mr. Panging for 16. And Mr. Rotan
For the state respondent.
for all the state respondents. Mr. Panging submits that he has filed his Ukalatnama today and also filed affidavit in opposition.
Yes, sir.
Opposition. Opposition. Accordingly, Mr. Soikia, you have also filed affidavit today.
Lordship.
Yes, it appears.
Mr. Soikia, learned counsel for the respondent number so and so also submits that he has filed the affidavit in opposition today. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that here there's a service completed in respect of all the respondents.
Yes, not sure.
Sir, I'm appearing
My
for
lords, is
27
reflected in my
respondents.
lord's last order and the order previous to that. It is reflected. Service is complete to
Your
all
name,
the
please?
PK Sarma, sir.
PK?
Sarma.
PK Sarma for the respondent number 27.
27, sir.
The service is completed to all the respondents.
As service has already been completed in all the in respect of all the respondents. This is a list the matter for admission hearing on. You suggested that?
No, that will be after the vacation if possible, Malad, that will be.
But that is a dilatory tactics, which is I would
Malad, these
say
certificates under challenge are of 2008, 2009, 2010. Where
we are
all
just
it
if
is
my
where,
learned friend would allow me
just
to
suddenly,
speak,
Malad, because of
I am
something, Malad, the
no.
brief has come, Malad, this, Malad.
It is a continuous
Okay,
deliberate contempt of
it is
apex
on-
court which is happening throughout.
The
I'm just
certificates
pointing
are
that out.
in question
20
issued in 2008, 2009.
No, you are committing contempt. Your clients are committing contempt every single day after the judgment of the Supreme Court. I'm just pointing it out. Please be very clear in what my
Okay,
submission.
okay. 28th of April.
No one is stopping you filing a petition for drawing contempt.
I will show the law what is preventing me to you next date.
You are the only one. It's not that you are the only one who knows law. Not
Let's
next
argue
subject,
today
sir.
only. I am prepared to argue now. If you have
Maybe you are prepared to argue.
I am ready to argue today. So don't show all these things to me.
Okay, okay.
You are a senior counsel, behave as one.
I am not.
You are. I can see your short gown.
He should come only.
Yeah, please, Your Lordship.
Yes.
This matter was posted yesterday, but certain documents which was not part of writ petition number 3. So, along with writ petition 63 and 97 has been listed today, Lordship. So, wanted to show one documents in writ petition 97, which was part of writ petition 97. Lordship, before getting into the grounds of my challenge in writ petition 118, Lordship, I'll just apprise how several writ petitions are being filed. What prompted me to file several writ petitions?
You were referring to who is writ petition?
Lordship, may kindly take up writ petition number 63. This was my first writ petitions that was filed before your Lordship.
63.
Lordship, in this writ petition, I'll just try to highlight some of the important documents that is part of the writ petitions, whereby Lordship, the election process was put to challenge, Lordship.
No. You, tell me the page number.
Lordship, may kindly come to page number 37. This is the bylaw of the Arunachal Cricket Association, Lordship.
37.
Before that, Lordship, may kindly come to page 63. This is the incumbency board, Lordship. From this incumbency board, Lordship, I just wanted to point out one thing, Lordship. They have the incumbent, they have resumed office on 25/10/2022, Lordship. Now, as per bylaws, they can hold the office for 3 years only. Page 39 of the same writ petition, Lordship. Page 39. This is Rule 13, Sub-Rule B. Rule 13, Sub-Rule B, Lordship.
14, Sub-Rule B.
13, 13.
13.
Lordship. It talks about election and terms of office bearers. Now here 13A talks about the office bearers. Who are the office bearer? President, Vice President, Honorary Secretary, Joint Secretary, Honorary Treasurer. Now B is important, Lordship. The term of the office bearer shall be 3 years. Now, Lordship, if we see the incumbency board, Lordship, this is the incumbency board of the President. Subsequently, I have in the next page, I have annexed the incumbency board of Vice President, Honorary Secretary, all those are there, Lordship. We can refer only this, Lordship, for my convenience, Lordship. TC Tok, who was at that point in time, he was the President, Lordship. He has joined the office on 25/10/2020. Now 3 years completes on 25/10/2025, Lordship, October. If you count, Lordship, from 25/10/2022, now election is supposed to be conducted after 25/10/2022, Lordship. 2025. Their tenure is over by October 2025. Now, since this incumbent, they were still holding the post, Lordship, the petitioners, they approached before the association and requested them to hold the election as early as possible. They approached them. But they were very much reluctant to hold the election, Lordship, till February, Lordship. Now, subsequently, they have come up with a notification in January, Lordship, page number 71, Lordship, Annexure 5.
Yes.
Now, it's clearly says the FX Council of the Arunachal Cricket Association is pleased to notify the AGM election of ARCA to be conducted on 24th February 2026 at Hotel Doni Polo International. Why? Subsequently, several other notifications. Next page, 72, Lordship. This is another notification. Affiliated District Cricket Association are directed to submit the name of representative, one authorized to attend the AGM scheduled for 24th February 2026. The name should be given on or before 14th February to the undersigned. Lordship, may kindly see this order, Lordship. Now, this order is passed by the Honorary Secretary. It's signed by the Honorary Secretary, Lordship. Now, when we talk about the election process, Lordship, there has to be an electoral officer, Lordship, who has to conduct the entire election process. Page 56, Lordship, may kindly come. This is the Rule 36 of the bylaw, Lordship. Rule 36, subclause 1. At least 4 weeks prior to the annual general body meeting, Lordship, this notification has come out, but there is no discussion about appointment of electoral officer, Lordship, at which an election is to be held. The FX council shall appoint an electoral officer who shall be a former central or state election commissioner. The electoral officer shall oversee and supervise the entire election process, including the scrutiny of the electoral rolls for the Apex Council, which shall include all nominations, candidatures being subject to his scrutiny in accordance with the rules. In case of any dispute, objection as to the candidacy, disqualification, eligibility to vote, or the admission or rejection of a vote in the elections to the Apex Council or any of the committee, subcommittee, the electoral officer shall decide the same, and such decision shall be final and conclusive, Lordship. Now, here, Rule 36 clearly talks about the electoral officer. He has to act, he has the power to convene and the election process, Lordship. He has all those sub rule 2, 1, 2, and 3, Lordship. The power lies before the electoral officer. Now, Lordship, we'll see the notifications, all those is coming forth from the Honorary Secretary, Lordship. Which is illegal, Lordship. He cannot, Lordship. So why we have submitted one representation, joint representation. Lordship will find that at page 73. Finding all those illegalities that was being committed by the Honorary Secretary, we have filed one joint representation before the authority itself, before the association, who is headed by the Honorary Secretary, of course, highlighting all those grievances. This was not redressed. So why, Lordship, we have rushed before this Honorable Court, alleging there are certain violation of the bylaws, Lordship. So why this first writ petition that was filed, Lordship? Lordship, in that writ petition, which is still pending, Lordship, Lordship has, I have read out that order, Lordship, yesterday. Lordship, in that order, when this writ petition was taken up, this Honorable Court, Lordship, has clearly observed certain illegalities that was being committed by the executive members of the association, Lordship. So it was clearly directed to conduct the AGM election accordance with law. That was the order passed in the first writ petition, Lordship. Lordship, in spite of this standing order, Lordship, they went ahead with the election process, Lordship. In the first election writ petition, our main contention was, Lordship, that they have not appointed the electoral officer, Lordship. Now, in the second writ petition, Lordship, Lordship will see the impugn notification, Lordship. Election was conducted, which is, Lordship, may kindly take up second writ petition that we have filed, writ petition number 97 of 2026, Lordship.
Okay.
Page number 107, Lordship.
This 126 is prepared today or on the other day?
Writ petition 126.
126.
This is different writ petition. This is different. Item number 4 is different, Lordship.
Okay, 4 is different.
This is different.
Okay. This is new petition.
The new petition, Lordship.
Okay. So address is let notice go, Mr. Ratan.
Yes, my lord. In fact, I will appear only in item number 2 for the respondent number 6. The rest, it is the association, the Arunachal Cricket Association.
In item number 1, this is the petition. The other two petitions are connected matters.
Correct, Lordship. Lordship, in item number 1, Lordship, writ petition 118. Now this result which Lordship was asking for yesterday, Lordship, 107, Lordship. Now this result was state in this writ petition, Lordship. Writ petition 97. Now my contention in item number 1, writ petition number 118. Lordship, in spite of stay of this particular election result, they are still functioning, Lordship. So why? How?
Yesterday, the question was,
They resumed the office before this election result, Lordship.
yes,
They stated in their impugn
the
order.
question was the timeline for declaration of the result.
Correct.
Where it was mentioned.
Lordship, declaration of result was on 24th February 2026, which is part of annexure at writ petition number 97, which is at page 107, Lordship.
97, page number 107.
107. Tema tu istri mana? This is the result which was state. Which was put to challenge in WPC number 97, Lordship. 2026, Lordship.
Mr. Rotan, you are not in this petition.
No, madam. I'm only in item number 2. That too, it's more the
Item number 2,
registrar.
already one date is fixed. We directed the registry to take those two petitions along with this petition as all are connected matters.
Yes, yes.
And he relied upon some of the documents which he has enclosed with those two petitions.
Item number 2 also, I'm only for the registrar of cooperative society.
Okay.
That entire matter is with regard to the cricket association.
Yeah.
That's why. Just a formal party in item 2.
Heard Mr. Zeni, learned counsel for the petitioner.
Lordship, in item number 1, Lordship, since this has been result has been stated, they cannot function, Lordship. That is my contention in writ petition item number 1, Lordship. How can they function, Lordship? So why they should be stopped, and then the impugn order, subsequent order that has been passed by them, that has to be stayed, Lordship. And then we can club all those writ petitions and we can hear it on 6th, Lordship, together, Lordship.
Pursuant to the order dated 15/3/2026, the registry has listed WPC number 63 of 2026 and 97 of 2026 along with this petition. And relying page number
107.
What is the page number?
7, Lordship.
107.
Annexure 13.
Referring to page number 107, referring to annexure number 13.
Correct.
At page number 107 of the WPC number 97 of 2026, Mr. Jimmy submits that the result of the election was supposed to be declared on 24 to 2026. 24 to 2026. But in the instant petition, by what is the impugn now? That notification by which they have assumed charge?
Charge assume किया.
Annexure 5?
Page 72, Annexure 4, Lordship.
Referring to annexure number 4 at page 72, the impugn office memorandum dated 13/3/2026, Mr. Zini submits that the office bearers of Arunachal Cricket Association has assumed charge on 23rd of February 2026. The deemed to have assumed charge and duties and responsibilities of Arunachal Cricket Association on 23rd of February 2026. 2026. And thereafter, thereafter, majority of the office bearers have taken some decision in respect of functioning of the cricket operation as per provision given in Article 19 and 21 of Arunachal Cricket Association bylaws. Mr. Zeni further pointed out that in view of the stay order granted by this court in WPC number
97.
in WPC number 97 of here it is part of the record.
Correct, Lordship. Page 69, Lordship, is the order.
Dated 12/3/2023. The impugn office memorandum dated 13/3/2026 and also the notification dated 13/3/2026 issued by the Honorary Secretary Arunachal Cricket Association are illegal and arbitrary and
Lordship, also page 80, Lordship, 17/3/2020, they have started issuing so-cause notice, Lordship. This also I have impugned against us.
and also the so-cause notice dated 17/3/2023 issued to the
2026.
issued to the
President Secretary Papumpare,
President and Secretary Papumpare District Cricket Association, Kamla District Cricket Association, West Siang District Cricket Association, Cricket Association of Upper Subansiri, and Tawang District Cricket Association.
Correct.
Are illegal and arbitrary. And thus by the said notification, office memorandum, and so-cause notice, the respondent herein are circumventing the order of this court passed in WPC number 97 of 2026. 97 of 2026. And under such circumstances, Mr. Zini has contended to stay operation of the said office memorandum dated 13/3/2026, notification dated 13/3/2026, and the so-called notice dated 17/3/2026, and also the circular dated 17/3/2026 regarding selective exemption from district level election. The submission of, no, having heard the submission of Mr. Zini, learned counsel for the petitioner, this court has carefully gone through the petition and the documents placed in record, and also there is the order passed by this court, by a coordinate bench of this court in WPC number 97 of 2026, dated 12/3/2026. 2026. And it appears, and also carefully gone through the impugn office memorandum, the notice, and the circular, and also the so-called notice. And it appears that in WPC number 97 of 2026, by the order dated 12/3/2026, a coordinate bench of this court has stated declaration of result dated 24/2/2026 till returnable date. Fixing the matter on 6/4/2026. However, in total violation of the direction issued in the order dated 12/3/2026, the respondents have assumed charge, deemed to have assumed the duties and responsibilities on 23rd February 2026. And also issued the notification on 13/3/2023 and the circular dated where is the circular? Page number? And the circular dated 7/3/2026, Annexure 8. And the so-called notice dated 17/3/2023. And thus, a prima facie case is demonstrated by the petitioner in its favor, and accordingly the impugn office memorandum, so-called notice, circular, and the notification dated so and so stands state till returnable date, list after 4 weeks.
Item number 4.
Receive shall list this matter along with WPC number 97 of 2026 and 63 of 2026. Yes, what is item number 24? Oh no, sorry, item number 4.
Lordship, I'll just, at this stage, Lordship, I'll just seek notice from this Honorable Court, Lordship. In this case, Lordship, it's already a covered case. It's pertaining to a land compensation matter, Lordship. Already, assessment was also done, Lordship. Now, at the later stage, after told, Lordship, the respondent side, they have come up saying that the area which was to be acquired for road construction as well as for electricity transmission line falls under the reserve forest, Lordship. Now, in the same reserve forest, Lordship, in the year 2011, there is a judgment from this honorable court. Same thing, Lordship. That same the reserve forest was de-recognized, Lordship, which I have annexed at page 43, Lordship, of the writ petition, annexer 6.
No, what is your grievance here?
Lordship, now in my lane falls in that same reserve forest which the respondents are contending, Lordship. Now that has already been de-reserved in the year 2011 by this judgment, Lordship, 2011 judgment, page 43, Lordship. Nunathang versus Union of India and others, Lordship. That is Denning Reserve Forest, Lordship. It was not done that reserve forest notification and that every procedure that was to be complied with, it was not complied. That was clearly held in this order, Lordship. And here also, Lordship, the main issue involved was in regards to a compensation matter, Lordship. Lordship, the judgment operating portion, Lordship, will find it. So here, Lordship, we have impugned the notification issued by the authority concerned, whereby they clearly says that the compensation amount cannot be paid to us, since the lane which is supposed to be acquired by the authority concerned falls under this Denning Reserve Forest. My contention is, Lordship, that was already de-reserved in the year 2011, Lordship, by this judgment, Lordship. Page 61, paragraph 52 is the operating portion, Lordship.
No, your land was acquired for construction of
Road and
power
grid for construction of towers, Lordship. Now, already assessment was also done, Lordship. Assessment done with the authority concerned, Lordship. Now, when it was the time for paying the compensation amount, suddenly they come up with this, Lordships, reasoning saying that the lane falls under Denning Reserve Forest, Lordship.
Okay. Heard Mr. Zini, learned counsel for the petitioner. Mr. Ratan for the respondent number.
1, 2, 4. All the respondents.
For all the respondents. The grievance of the petitioners are that
The reservation.
the grievance of the petitioner being sought to be addressed in this petition is that their land was acquired by the state respondent for construction of NH 113 between bracket Dimui Brahmakund road project, and also for establishment of power grid utility assessment. But they have not, in which year it was conducted, acquired?
It was between 2018 and 2022.
In between 2018 and 2022. 2022. but till date, they have not been paid the compensation amount which they are legally entitled to. Is there any further submits that after whether notification was issued?
Notification will also be signed at 867. 18 December 20.
Annex 10, Lordship.
Annex 10. Mr. Zeni further submits that the respondent authorities have issued the notification on 18th of December 2020, but thereafter, the respondent authorities refused to pay compensation to the petitioners on the ground that the land allegedly falls under the reserve forest.
Your Lordship, Denning Reserve Forest.
Reserve forest. And the said contention was made on the basis of the preliminary notification, date of which back to the year 1977. Mr. Zeni further submits that the said notification issued in the year 1977 never attained finality.
Correct.
And as such, no legal status could be attached to the same. And being aggrieved, the petitioners approached this court by filing the present petition. He also submits that the issue has already been settled by this court in the case of
Nunai Taing versus Union of India.
Nonne Taing versus Union of India, reported in, what is the citation?
2011 Supreme GAU
2011
233.
Supreme GAO
233.
233. And under such circumstances, the petitioner has applied for issuing direction to the respondent authorities to pay the compensation and also to quash the notification, preliminary notification issued in the year 1977. The submission of Mr. Zeni, learned counsel for the petitioner, needs further consideration. At this assess, notice be issued to the respondents returnable in 4 weeks. However, no formal notice is required to be issued since Mr. Roton, learned additional AG, entered appearance and received notice for all the respondents. However, extra requisite copy of the petition be furnished to him during the course of the day. Please the matter after for
Lordship.
The PCCF and also the NHIDCL may be made a party. The principal chief conservator of forest, as well as the requiring body, that is the NHIDCL.
Okay. During the course of deliberation, Mr. Roton has pointed out that the petitioner herein is not allied the requiring body, that is the NHIDCL, and also
the principal chief conservator of forest.
Principal chief conservator of forest.
Also, Lordship, then power grid also, Lordship.
Power grid.
And the power grid is respondent in this petition, as they are the necessary parties. Mr. Zeni submits that he will take necessary step for implement of those those parties as respondent in this petition before next date.
And Lordship, a small observation. during the pendency, there will not be bar for releasing the amount.
It is being clarified that pendency of this petition will not be a bar for the respondent authorities in releasing the compensation amount which they are entitled to.
Item number 12.
Yes, here pleadings completed.
My lord, the matter has become infructuous, man.
How?
My lord, this is the tender was for 2024-25, man. Financial year 2024-25, man. Now we are on 25-26, man. 26-27.
This matter was never heard, Lordship. This matter kept on pending, Lordship.
My lord, what happened? His answer bid was rejected, my lord.
In the year 2025, you remain absent?
Yes, my lord.
Huh?
Yes, ma'am.
So we close the matter then?
Yes, ma'am.
Lordship,
Mr.
just,
Sini, learned
Lordship,
for the-
just one thing, Lordship. Our simple contention in the writ petition was, Lordship, in regards to BOQ, Lordship, which Lordship will find at page 64 of my writ petition, Lordship. Now, due to this, my tender paper was rejected, Lordship. At least my client, he wanted to know, Lordship, from the records, which was alleged from the respondent side, saying that this was overwritten, Lordship. Now, as per the conditions of the tender,
Hmm.
My lord, page 44, my lord. Page 44, my lord. Roman 3, my lord. Use of correction fluid is a ground for rejection, my lord.
clause 16, Lordship, page 44. 16 subclause 3, Lordship. All entries in which should be legible and filled clearly, and overwriting or cutting which is unavoidable shall be signed by the authorized signatory. Use of correction fluids shall be liable for rejection, Lordship. Till today, Lordship, my client want to know, Lordship, whether he has used the correction fluid or not. My contention, Lordship, in this case, Lordship, my client says that he has never used the correction fluid, Lordship. So why is the original record was called for, Lordship? Lordship, may kindly go through the original record, Lordship, which I am not privy to see to it, Lordship. That was the whole issue involved in this case, Lordship.
As per our affidavit, my lord, serial number 2, 3, 16, and 21. Correction fluid has been used, ma'am. Serial number 2, serial number 3, 16, and 21, ma'am.
Let him say
Yes, my lord.
for his satisfaction.
Yes, ma'am.
Lordship, I just want to get that satisfaction. Otherwise, Lordship, I have to just apprise. I have to also be apprising my client, Lordship, whether that white fluid is used or not. Let me. It is not there, Lordship. My client says that he, of course, just to avoid all those using of white fluid in a Lordship, since white fluid was not allowed to be used, he told me that he has written it by a pencil press and eraser was used and he has written by pen or writing only. But he has never
Overwriting
used
is there.
the white fluid. I don't.
Overwriting is there.
Overwriting is of course there, but white fluid was never used.
No, it cannot be said exactly.
Yes, sir.
But it appears that fluid is used.
Lordship, if white fluid is used, mark will be there. If, even by touching, Lordship, we can know that white fluid has been used.
But
that is not there, Lordship.
It was the application of mine by the tender board, my lord.
Anyway,
Yes.
since the financial year is over,
Yes, sir.
then we have to close this matter then.
Supply already done and payment already received.
Okay.
It is supply.
Okay. Heard Mr. Zaini, learned counsel for the petitioner. Mr. B. Pisa, learned standing counsel for the respondent number
126.
126. Mr. Tarak for
7.
7. During the course of deliberation, Mr. Pisa has pointed out that this matter became infructuous as it was relates to a tender for the concerning the financial year 2024 and 2025.
Yes.
2025. 2025. And accordingly, taking note of the submission of Mr. Pisa, learned counsel for the petitioner, and also the submission of Mr. Zaini, learned counsel for the petitioner, this matter stands closed for being infructuous.
Lordship, one observation may be made. Our Lordship petitioner is at liberty to approach any forum for claiming compensation. Since I am still claiming that my tender was illegally rejected, Lordship.
Okay. However, petitioner is the petitioner is granted liberty to approach any authority by filing appropriate application in respect of
Claiming compensation for illegally rejecting.
no, we are not determining it whether rightly or wrongly it was rejected.
Yes.
We are closing the matter since it became infructuous. No observation.
For further any grievances.
No. We are not determining the merit of the petitions.
Right.
Item number 16.
May Your Lordship. Your Lordship, service report with the exponent number 2 is still awaited, Your Lordship.
Service awaited.
Yes, Your Lordship.
Upon respondent number
2, Your Lordship.
you want to take fresh step?
May Your Lordship will still wait for the.
Wait.
Yes.
Heard miss, your name please?
M. Sawyer.
Learned counsel for the petitioner.
Your Lordship, however, we have learned unofficially that the respondent number 1 has received the service rule. So kindly matter will be fixed on 6th of April. Your Lordship.
6th of April. April. Okay. Office note dated 25/3/2026 indicates that service report in respect of respondent number 2 is still awaited. Accordingly, it is provided that SSL list the matter on 6th of April.
Yes.
Awaiting service report upon respondent number 2. Respondent number 2.
Obliged.
Item number 18.
By me, please, Your Lordship.
Yes.
Your Lordship, I'm appearing for the petitioner in this case. on behalf of Shri Papnia Karga. And by way of filing this application, we are challenging the order of the ADC. That is at page number 20 of the petition, Your Worship.
No, today this IA is listed.
Your Lordship, on the last date, Your Lordship had said that we will hear the matter in total and dispose it altogether because they filed the IA for vacating the interim order that has been passed in our favor.
Okay. Mr. Tafo,
Yes,
are you
Malab,
ready?
otherwise, Malab, if Lordship feels that Malab, the matter can be heard at later stage, Malab. But Malab, we are praying a simple Malab, direction that the party should maintain status quo. That's all, Malab, nothing else. Otherwise, Malab, this is undivided family property. And the petitioner is, Malab, after getting the interim order, he has now collected material for constructing a house. That will create Malab, a law and order problem. Malab. Fight would be there. That's why we wanted that direction. Malab. We are not against that interim order should be vacated totally. Malab. But further direction that the party should maintain status quo. That's all.
No, what was the earlier order?
It state the order passed by the executive magistrate. That was statement. Now, because of new development, the petitioner wants to construct a house at that disputed place. This undivided family property. They are all brothers, petitioner and respondents. That's why instead of creating a law and order problem, may kindly, of course, that may be state. We are not against that. But a further direction that party should maintain status quo depending of this petition, writ petition.
Your Lordship, in that
So
case,
if stay is granted, then why the status quo has not been maintained? Yes.
Your Lordship, the thing is that the petitioner herein, who's the eldest son of the deceased Tumpak Karga, who's the head of the family, in whose favor the possession of the particular land was. So when this matter was still pending, the father of the petitioner passed away. And because of that, now, since the mother is still alive, the petitioner is taking care of the mother and he's building a house for the mother. And the brothers are now opposing to that fact because they're fearing that this particular land, although it's not divided, that this petitioner will take over that land. That is why they are causing trouble.
That's totally totally not true. The
There is
petitioner
another case also
stays in
against the mother.
And that is places in West Yang district, totally very far from here. Now the allegation, they claim that he's looking after her. And he is not the eldest, his second brother, second eldest.
Eldest son, Your Lordship.
No, he's second. No, he's second. In reality, also his second brother. All are brothers, Malad. So, what's the harm in maintaining status quo? Otherwise, Lordship will, if something happens between them, taking the land dispute, that would be more harmful than family members.
Declaration.
That's why.
If I may please, Your Lordship, if the prayer that my senior is making, if that is to be done, then the entire petition could be quashed. I mean, like the order could be quashed and the entire petition can be disposed of, because this matter has actually been pending since 2023. So if Your Lordship could quash the order and then dispose of the matter, then the entire dispute will be solved, because I want the order to be quashed and they want the status quo to be maintained. And until and unless the case survives, that cannot happen. Because the order of the ADC, if Your Lordship will see, it is clearly illegal.
Yes, madam.
You were the petitioner in the writ petition?
No, other respondent.
You were the respondent. Okay.
Madam, this
So
matter will
here
take,
the only pair is to maintain status quo
yes, madam. Till pendence
This
of the
petition?
petition. Yes, madam.
in this petition.
Yes.
Till pending.
Till disposal of this writ petition, madam. My
Your
lord, there is
Lordship, if
slight
I may.
confusion.
In the the impugned order, the learned ADC has passed the order saying that status quo should be maintained and that no construction should be done in the said property. But when we had come before this honorable court challenging that particular order, this honorable court had stayed that order. So in doing so, the petitioner right now, he's constructing the house in the land, and because of which the respondent is being aggrieved.
So I is filed by you.
Yes, ma'am.
So we can finally dispose of the entire matter.
No, I'm agreeing to that, madam. But what I'm submitting is, madam, if the writ petition not disposed of, madam, the IA may be considered, madam, for maintaining status quo by the parties.
No, we can dispose of both the matters.
Yes. Then
Yes, Your Lordship.
let her continue.
Where is the order of the impugned order?
Page 20, Your Lordship. At page 20, Your Lordship. If Your Lordship will see, the learned ADC has construed these 5 issues, and then thereafter the ADC has gone ahead and disposed of, has taken into consideration the issue number C and issue number E. And then thereafter, issue number A, B, and D was referred to the village authority. Now, as your Lordship is aware, after the enactment of the Arunachal Pradesh Civil Courts Act, the Deputy Commissioner and the additional Deputy Commissioners they no longer have the power to administer criminal and civil justice. So the mere reading of this particular order itself suggests that the ADC has has exercised a jurisdiction which it no longer possesses. And moreover, this application looks like an application under the order looks like an order that has been passed under section 145 CRPC. However, that has not particularly been mentioned. But then there was an application that was referred by the respondent number 3 here, implied respondent, under section 145 CRPC. So all of those applications, there was one more FIR that was lodged by the mother, alleging that the private respondent had physically assaulted her, and mentally and emotionally as well. So all of those applications were taken into consideration, and then the ADC had passed this particular order.
So your primary contention is that this order was passed by the deputy ADC without having any jurisdiction to pass such an order.
Yes, Your
Is
Lordship.
it?
Firstly, yes, Your Lordship. Secondly, no hearing was conducted of the petitioner. There was a notice that was issued. However, the petitioner could not appear, and there was no hearing that was conducted before passing of this order. And moreover, before passing an order under section 145 CRPC, drawing a preliminary order is a must, Your Lordship. That has also not been done. So there is violation of principles of natural justice of the petitioner as well.
Is this order is passed under section 145 CRPC?
Yes, Your Lordship.
Okay.
And also one more ground that we are taking in the petition is that, Your Lordship, there is an appeal that is pending with regard to the same land before this honorable court it is registered as FAO number 01 of 2016. However, this particular dispute is between another party by the name of Binken Nomok and Tumpak Karga, who is the father of the petitioner. This particular piece of land was supposedly purchased from the Nomok party. However, that is being disputed by them, and the matter had come up before this honorable court as an appeal, and that is still pending. So our contention is that when a civil dispute is pending before a civil court, 145 CRPC proceeding, that is a parallel proceeding, cannot exist. And thereby it also renders this particular order illegal. So these are the main grounds that we're taking before this Honorable Court. And there are a few judgments also that I had submitted before this Honorable Court on the last date of hearing. But if that is not in the file, my associate is there, he'll hand it over to your Lordship.
So before passing of this order by the ADC,
yes, Your Lordship,
the civil appeal is pending before this court.
Yes, Your Lordship, there is an appeal that is pending. So initially, the other parties who are challenging the title of the Karga family, they had filed for a title suit before the village authority, which was passed in favor of the Karga family, that is the father of the petitioner, Tumpak Karga. Thereafter, they had again approached the Sessions Court, the District Court Alo, by way of filing a title suit, fresh title suit, instead of coming before the District Court as an appeal. And thereafter, that particular case was also dismissed, and the possession and titleship was passed in favor of the father of the petition, that is Tumpak Karga. And after that, the Nomok parties have again approached this Honorable Court by way of filing FAO number 1 of 2016, the appeal. And that particular matter is still pending before this Honorable Court. However, the title and ownership is still in favor of the father of the petitioner, that is Tumpak Karga, who right now, he's not alive because he passed away when this particular petition was still pending. He passed away in 2024, I believe, Your Lordship.
So you have three grounds here.
Yes,
One
Your
is that the ADC has no jurisdiction to pass the
No
order.
jurisdiction. Yes, Your Lordship, under
Yes,
the Arunachal
second
Pradesh
is,
Civil Courts Act.
yeah. The second is the order was
Violation
passed
of-
without giving an opportunity of being heard to the petitioner.
Yes, Your
And
Lordship.
thirdly, in respect of the said plot of
Appeal
land,
being
one
pending.
civil appeal is pending.
Yes, Your Lordship.
So these are the three grounds.
Yes, Your Lordship.
Okay, Mr. Tapo.
This very peculiar the petitioner is the appeal which is pending is against our father by a third party. That's a totally different matter.
No, in respect of the disputed land.
Yes, of course. And in that, it's not that our father was there. There's one more person is there, Tumge Karga. He was one of the parties.
No, maybe, but in respect of the same plot of land.
Yes. But besides that, now the dispute between us is not regarding entire land. This plot is not a small plot of land. The dispute was of larger area between the third party and our father and one of our uncles. They were our father and with third party. It's not that the dispute is between us. If the civil dispute was between us, the matter would have been different. The dispute is not between us. It's between our late father and third party.
No, maybe, but concerning the same plot of land.
Yes. That's what it was larger area, not this. It was not demarcated saying this for this particular plot. This appeal is pending. It's for entire area.
Okay, in respect of other two grounds, that opportunity of hearing not being
definitely notice were issued, man. They didn't appear that matter would be different. Otherwise, Lordship will see the application which we have filed before the of course, in
my question is clear that whether opportunity of being heard was afforded to the petitioner.
Notice were issued, my lord.
Issued whether it was served.
Malad, that would be apprised by the state respondent, Malad, whether they have served
Yes.
or not. Yes, Malad, that part. Therefore, Malad, but they have made the public prosecutor as a respondent, Malad. That they know that this order was passed under section 140 of CRPC. And the Lordship will kindly, just for perusal only, I'm not reading the entire page 28, but this is the in the writ petition itself.
Mm. Mm.
Lordship will see the application was filed under section 145 and 147 of CRPC.
Mm.
And this application was accordingly adjudicated and this impugn order was passed.
Mm.
Lordship, I have already submitted, Malab. This is undivided. That is not disputed by the petitioner also. This plot of land where the mother is staying, because the father has already expired, mother is staying, is undivided family property, land.
Mother is no longer alive.
Mother is there.
Oh, mother
She
is there.
only, yes. Father has expired. So the petitioner, who is the second brother of the family, he stays at Itanagar. And in the garb of saying that he wants to construct a house for mother, whereas already a house was already there at the village. And he wanted to kind of grab the land. Definitely other brothers will object to that one. And there was a likelihood of violence at that place. Therefore, the respondent approached the executive magistrate under section 145 to maintain status quo. It's for them to approach a civil court if they want to have the land. They cannot forcibly enter and try to capture the land.
No, Mr. Tafo, you see,
Yes.
here,
Yes.
we will only examine the impugn order.
Yes, madam.
If it fails to withstand the legal scrutiny, then we have to set it aside.
Yes.
Then what kind of other reliefs can be granted here?
Madam, definitely, if Lordship finds that the order was not passed in accordance with section 145 CRPC, madam, Lordship may quash that one and direct the executive magistrate to do it according to law. Madam. Otherwise, there would be another kind of trouble for both the parties. It will matter.
No,
Never be solved.
if the deputy commissioner has no jurisdiction to entertain this matter.
No, executive magistrate definitely has the power, madam. Because additional deputy commissioner has the executive magistrate power. And the 145 is always by the executive magistrate. Because by holding the post of additional the deputy commissioner or extra assistant commissioner, they are executive magistrate by designation in Arunachal Pradesh. They will exercise the powers of 145 CRPC. That is not disputed. The manner in which the order has been passed might be disputed, but it's not disputed that the additional deputy doesn't have that power under 145. That is not disputed. The manner might be they might question the manner, but the power cannot be questioned.
No, in the meantime, this CRPC is not there.
Madam?
CRPC, that BNSS.
No, now BNSS has come, Malad. But at that time, when Malad, these applications were filed, it was under Malad CRPC only.
Okay.
Yeah.
It was enforced.
Yes, it was not amended, Malad.
Now, can we again remand the matter to the ADC?
Well, it will prejudice the respondent. They will have no place to approach once that order is passed. There will be remedies less against the action of the petitioner who is trying to grab the land.
No, you file a partition suit. Why remedy is not there? If it is your ancestral property, you file a partition suit.
Remedy in the sense, because 145 CRPC, this application definitely filed to protect from the law and order.
That's all right, but the ADC cannot decide the title, no?
No,
Title has to be
no,
decided only by the civil court.
we are admitting to that law, point of law. ADC cannot adjudicate.
Hmm.
We are admitting to that. But what we are submitting, this order has been passed under section 145 CRPC.
Hmm.
And I have shown the application, based on those applications, this order was passed.
Hmm. No, the question is, can we remand the matter again?
That would be proper, it would serve ends of justice to both the parties.
No, that will also be a temporary.
Yes,
for final and settle the matter once for all, you have to file a partition suit.
Yes, both the parties,
according to me.
Yes, but both the parties can approach the civil forum, let's say Gambura or the civil court.
Hmm.
But law and order has to be maintained in that plot of land.
Okay, till then, status quo be maintained,
Yes,
madam.
that can be done, madam. Yes.
Yes.
Your Lordship, my humble prayer would be.
We are setting aside the impugn order.
Yes,
But
Your
you
Lordship.
maintain the status quo till the matter is settled.
Yes, ma'am.
Your Lordship, the thing is that there was a notice that was issued for a Kaba meeting as well, the village level authority. However,
Yes.
the respondent did not appear. So what can be done is actually this matter can be amicably settled between the parties, either through a village authority or before this honorable court had given us opportunity to settle it before the mediation center. But then the respondents were not willing to. Now the respondents, they are only trying to get some kind of relief from this honorable court, even after this matter is disposed of. And they just want to benefit from that, which cannot happen, Your Lordship. If there is anything, they have to figure it by themselves.
Let there be a direction that both the parties shall approach the village court.
Or
Village
the civil
authority.
court, both. Any of the
Village
forum.
authority.
Appropriate
ma'am.
civil authority.
Or appropriate
Yes,
civil
madam.
authority until disposal of the dispute.
Yes.
Status quo be maintained.
Yes, madam. That would be okay for us.
Yes, madam.
Your Lordship, the thing is that this particular house, the petitioner has already spent so much of money in construction materials and everything.
No, that's all
So
right.
now-
That's all right. But how can you construct it if it is Esmali land without being partitioned between the family members who are entitled to the same?
Because now after the death of the father, Your Lordship, the mother is the head of the family and she's taking care of everything. And it is only on the direction of the mother that the petitioner is doing these constructions.
Well, that's now that plot of land, Lordship has already seen. She herself has submitted that dispute of appeal which is pending was between our father, the respondents, were our uncle and the father. Uncle is still alive. He would be the caretaker of the entire land. Lordship, kindness, see the appeal. This is the dispute, land dispute was with the third party. It was in that suit, the uncle of all of us, Tumge Karga, and our father, Tumpak Karga, who is expired now. But Tumge Karga is still alive, uncle. Because title was given in favor of Tumpak Karga and Tumge Karga. Both of them. So it's not that the mother would be entitled to look after, saying that she is the head of family. No. Regarding the land, Tumge Karga is still alive.
Okay, you go and approach the
Yeah, that's what I'm submitting. Not
village authority or civil.
Yes,
court.
yes.
Your Lordship,
And
if I
till
may
then,
please.
till then, maintain the status quo.
Yes, ma'am. I'm obliged, madam. That would serve the ends of justice for both the parties. We are not even cousin, real brothers, madam.
Yes. It is unfortunate that two real brothers are fighting
Yes.
before this court. Okay, we are setting aside the impugn order.
Obliged, madam.
Give your last.
Item number 19.
Good afternoon, sir.
Yes.
I brought 2010 rules.
Yes.
Page number.
43.
Page number.
43.
Huh?
43. This 4.4.
Yes, Mr. Nagar.
Well, in this the writ petition, repeatedly I'm submitting the clarifying the position of the case. The petitioner joined as associate professor in RGO on 6/8/2015. First application for promotion under CAS for professor on 15/6/2018. Rejected on ground of not eligible. That means he filled the form based on the 2018 regulation. 2018 regulation he filed, and thereafter his rejection of the screening committee of his application rejected by the screening committee of RGU on ground of incomplete application form and not eligible because he was not having that much of the criteria fulfill the PhD.
No, PhD guide.
And that is page that is mentioned in my page 67 of affidavit. And second application for promotion to professor under CS filed by the petitioner on the 2/9/22. 2/9/22 under UGC regulation 2016. Before 2000, the 4/9/2020 he filed on 2018 regulation. Then 2000 thereafter the registrar sent a letter to him to apply on 2016 regulation. Accordingly, he applied 2016. Then his case was considered, which is mentioned in page 69 of affidavit. And thereafter, basing on 2016 regulation, his case was considered, appointed to as professor under CS on 24/2023, page 75 of writ petition, his appointment order. And now he has challenged his own appointment order. The petitioner has challenged his own appointment order, memo number 80-145, appointment 2017, dated 24/2023. So 23 appointment has been challenged by himself. So in this case, Lordship, since he has not qualified the criteria, he was rejected by the expert committee. Expert committee, which is in my affidavit. Which is mentioned in mentioned in my affidavit para number, more particular para 4 and 10. Para 4, little bit we have to go the back to the 2000 initial stage of this case. Para 4, Lordship. Due to national lockdown, page number 3.
Yes.
Due to national lockdown, 7th line below. Due to national lockdown, SOP guideline and safety and security of the candidate on account of COVID-19 pandemic subsequent years, the CS promotion, both interview and non-interview, were delayed. However, delay of conducting CS interview will not affect the petitioner or any other candidate. It is pertinent to mention here that from the date of qualifying of the interview, the candidate will be promoted respectively. However, in the instant case, the petitioner was qualified Lordship, and passed the interview in year 2023 only, 23. Regarding the interview shortlist for promotion to professor in 2020, the interview was conducted, but he was not qualified. The petitioner was not called for interview on the ground that under UGC, new UGC regulation 2018, evidence of successful guiding PhD scholar is mandatory. And in the application of the petitioner, no evidence of successful guiding of PhD scholar was enclosed in his application, and no scholar had been awarded PhD under the guidance of Dr. Satish Kumar at the time of screening.
So, Mr. Nabam, his case was considered under the rule 2018.
16 considered, 16.
On route
As per the instruction.
In the year 2016.
16 regulation, UGC regulation, 2016 regulation. That because 16 regulation that was not mandatory.
In 18 also there is one regulation.
18 regulation, yes. Though there is two regulation, 2018 UGC regulation and 2016 UGC regulation.
But we can opt one
18
only.
regulation, it was mandatory. PhD, that scholar guiding scholar was mandatory. That's why he could not qualify. Then 2016 regulation, he applied praise. Then his case was considered.
2016 rule.
16 regulation, UGC regulation.
Okay. Whether it was compulsory in that regulation? Under that regulation?
Lordship, that's as per the CS scheme that that one should there is screening test, which screening test conducted by the expert committee. That is sent by the UGC. The UGC they sent the committee, expert committee, 3-member expert committee. So screening all the eligible candidate, those applicant, they were screened through documentation or through interview. Then his document was disqualified because he did not attach all those required document. So he was disqualified. Disqualified in the first application, which was filed based on 2018 regulation. 2018 UGC regulation. I'll clear the point. Hence his application, para 4, I'm continuing the para 4, Lordship. Hence, his application form was incomplete. Consequently, the university authority asked the petitioner to reapply. Accordingly, the university authority did not consider the petitioner's request for retrospective promotion effect from 2018. Further, university authority in circular dated 19 to 2020, page 4, Lordship, 220 had requested all the candidates to apply under UGC regulation form of 2016. So that is in page 9, this annexure, Lordship, page 9 of affidavit, my affidavit. Page 9, yes. Page 9 of this UGC regulation 2018, Lordship. This. Then now I'll come to para 10, page 5, Lordship, of my affidavit. The deponent beg to state that in the year 2018, the petitioner has submitted in application format for promotion from associate professor to professor under CS in term of UGC regulation 2018. However, the screening committee found that eligibility criteria of evidence of having successful guiding doctoral candidate was not fulfilled by the petitioner. Thereby, the petitioner was not eligible for the interview for promotion from associate professor to professor, Lordship. It is pertinent to mention here that as per UGC regulation 2018, under the CAS promotion from associate professor to professor, one must have eligible criteria of evidence of successfully guiding doctoral candidate, and petitioner has no such eligible criteria. Thereby, the university authority has directed the petitioner to apply a fresh application as per the format of UGC regulation 2016, amended 2010, Lordship. Instead of 2018, instead of UGC regulation 2018 point 6.3. What's it point 6.3 there? 6.3. Thereafter, as per the direction of the university authority, the petitioner and other have applied a fresh permit in the year 2020 under UGC Regulation 2016 for promotion from associate professor to professor under CS promotion. However, due to the poor performance of the petitioner in the interview, board held in the month of May and June 2021, the selection committee did not promote him to the post of associate professor to professor under CAS. However, by the letter dated so-and-so, dated 24/9/2021, the university authority communicated him to apply in a fresh format as per UGC Regulation 2016. The petitioner again in the 2022 had applied for the said post under application format of UGC Regulation 2016. And petitioner was successfully in the interview and selection committee had selected him for promotion from the post of associate professor to professor under CS case. As such, the petitioner has no locus standi to claim for retrospective effect from the date of eligibility. Because if this is the case, and in his writ petition, he has submitted a representation. A representation also he.
No, Mr. Nabam, tell me one thing. In which year he become eligible for promotion to the post of professor?
Of course, as per CS 2018.
2018.
But he was not qualified during that screening
2018.
test. 2018.
And at that point of time, the 2016 rule was in force.
16 rule was in force.
And, as per said rule, the PhD guide is, the criteria of PhD guide is compulsory.
Compulsory. 18 guidelines, compulsory.
18 or 16?
18.
No, his case was considered under which regulation? 16 or 18? 16.
16.
Whether in the regulation 16, there's a criteria of PhD guidance is compulsory or not?
Oh, no.
No, that's why his case was considered 16 because he was supposed to fill the form, application form based on 2016, but he filled the form based on 2018. So 2018, the PhD guiding is compulsory, mandatory. 2018 because that was the latest one. So for consideration, he was. After rejecting his application, he was sent a letter to file a fresh application based on UGC 2016 regulation. Then 2022 he filed and he was considered. 20 he filed and 23 he was considered. This is the case.
No, second time he filed the application under the regulation 2016.
16.
And in that regulation, there is no requirement of this PhD guide.
Yeah, Lordship. This is the case.
Okay.
This is the case.
So why it cannot be reviewed?
No.
Because at that time that qualification was not there, that criteria was not there.
But Lordship, here I will see. Check 2000 page number 10 of this UGC regulation. Page number 10 of my affidavit. Page number 10, 2018. Here, Raman 4.
Okay, that's all right. I have shown it yesterday.
And
no, if the requirement of successfully guiding doctoral doctoral candidate, then why his case cannot be considered now with effect from the date from which date he become eligible?
2000 based logic is very simple here. 2018 regulation, based on regulation 18 he filed, and that regulation mandatory the PhD guiding evidence of having successfully guiding doctoral candidate was very necessary. Here it is mentioned here. And 16 that was not there. That was 16 that is not there. So we consider his case because based on 2018 he is disqualified because he don't have that the evidence of having successfully guiding doctoral candidate.
No, that's all right. That's all right. If his case can be considered in the regulation 2016, where this requirement of this eligibility, that clause 4, evidence of having successful guiding doctoral candidate, is not there. So why his case cannot be considered under the regulation 2016?
No, based on the 16, we have considered his case. And he was appointed in 2023 Lordship.
That's all right. Why retrospective effect cannot be given to him?
Retrospective effect, the ground which we are not considering his case is that he has not qualified under this regulation.
No, under 18 regulation, he is not qualified. Under 2016, he is qualified.
But Lordship, date of interview will be counted. That of filing application will be counted. In this, so 2016, based on 2016, his application was filed.
They have written in writing. They have given in writing.
His application was filed. The application was to page number 39, Lordship. Page 39 of my affidavit.
Of your affidavit.
Yes, Lordship. And this is the application that he has filed the correct application. And this is
page number 30.
Page 39 of my affidavit, Lordship.
39.
2016 regulation. This is the format of 2016 regulation.
2000.
Application for promotion under CS. So and so and so and so. Dr. Satish Kumar. So and so, so and so. So date of eligibility, so and so. So and so. Now, thereafter, basing on this application, he appeared an interview and his case was considered and he was appointed as a professor on the 24 September 2000.
Okay.
He was appointed on the Lordship 24 to 2023. Lordship, this is the case, Lordship. And regarding financial benefit, we are ready to give him. And Lordship, in his application also, he has already admitted that he was rejected. He could not perform well. In his representation, he has admitted. It is in his petition, with petition page number, Lordship.
Page number?
Lordship, in his writ petition, page number 77, annexer 10 of his writ petition. To the Vice Chancellor. Annexer 10 series. He has filed 3 number of representation before before the Vice Chancellor. That is dated to the Honorable Vice Chancellor, Rajiv Gandhi University, Ronald Remote Natural Pradesh, subject request to consider my case promotion as professor with effect from 6th August 2018. With due respect, I would like to bring to your kind notice that I had joined this institution in the capacity of associate professor in 2015. After 3 years, I was eligible to promote as professor in case in 2018. I applied several times when the internal advertisement issued to all faculty in university, but authority could not conduct interview 2018-19 and 20 because we admitted that these 2 years we could not conduct because there was corona. An authority conducted interview in May 2021. Lordship, this is the point. But I could not success in the interview, Lordship. As per the rule of UGC, the applicant could not success in the first attempt. He himself could not admitted he could not attempt. He could not succeed the attempt. He can fill the form after 1 year. As per the rules, if candidate does not qualify in interview, then after gap of 1 year, he has to press application as per the regulation. There is rules. Again, I applied in 2020 for case promotion, and then authority conducted interview in February 2023. Lordship. I got promoted as a professor in case from level 13 to level 14 with effect from February 2023. Now he is serving. So far as my promotion is due from 2018, but I was promoted as professor in the Department of Education with 24 of February 2023. I got great loss in my career. I request your good self to consider my promotion as professor from 2018. I had been applying for case promotion since 2018. Authority could not conduct interview. It was delayed by the administration, but not by the applicant. Again, I request your good self to consider my promotion with from 6th August 2018. So he is seeking, and authority may also given financial benefit on grant of case since the applicant is eligible for promotion, so and so, so and so. So this is the craft of the case.
What is your case now?
Sir, I joined Rajiv Gandhi University as associate professor in 2015. Right after 3 years, I was eligible for professor. On the very first day, I had lot of papers. My form is not okay. They were doing. They're not treating me good. And every time when I went to the clerk, what happened with my form? Rejected. So after that, I approached to the vice chancellor. I said, sir, I have 300 points. Why my form is rejected? Okay, no problem. Sit down. He called the professor. He called the professor in charge. What happened? Okay, sir, first page of this form is not okay. First form is not okay. First page is not okay. That's why wrongly we have done. After that, they told me you can fill the form 2016. He was asking me you have filed the you have filled the application 2016 18. I said to them, why should I fill the form 2018? I got associate professor in 2015. My rule is 2010 and 2016. I have to apply. After that, they gave me order of 2016. You can fill the form. That's all. In the gender, I told the respondent number 3 mentioned false statement in the affidavit in reply at page number 4, page number 3, Rajiv Gandhi University was not scheme. Interview in regular interval. I was eligible for professor 6th of August 2018 and 19. There was no lockdown. The authority did not conduct an interview March 2020. And multiple requests were made to respondent number 3 time to time 6th of August 2020. Again and again, I was applying. They were saying to me, "You are not okay. You are not." Basically, sir, baat kuch aur hai. There is another matter. Local girl is there. They want to promote them. They want to make her senior, basically.
बताइए क्या सर बताइए
But while you have applied for the first time, you have applied under the regulation 2018.
No, sir. I applied 2016.
No,
A false statement is a totally false statement is they're giving.
Pardon?
False statement is there. False statement is there. There is no form.
No. Why he should make a false statement before the court?
I came to know that I applied on basis of 2016. They had to know any other answer. They told they make a plan. They said they applied. Satish applied to 2018. Why should I apply for 2020? I know it. I had not produced PhD.
No, this is not the way. Please don't be so emotional here.
Okay. So this is the regulation of 2016 or 2010.
Yes, sir.
This is 2010 regulation. And the 16 regulation is.
Yes, I have.
You have filed.
Yes.
It is with the record.
Yes.
Okay. Heard, Mr. Satish Kumar Lanet. No, petitioner in person and Mr. R.S. Nabam.
Arnabam, sir.
Arnabam.
Arnabam.
Arnabam, learned standing counsel for the respondent in varsity. Argument concluded. Judgment reserved.
Lordship. Highly obliged.
Item number 20.
May it please your lordship.
Mm.
Your lordship, this petition is under Article 226.
Mm.
It pertains to the recovery of excess amount from the incumbent who has already retired.
Okay.
His pension,
He retired as
he retired as assistant mason. He's Group D employee.
mason.
Yes,
Group D or Group C?
assistant mason. It is Group D. Yes.
Group D.
Yes.
Sure.
But not sure. But it comes. It should be either Group C or Group D.
Okay.
But not above that.
When he retired?
He retired on your lordship. He retired on 31/10/2022 from the office of PWD, your lordship, Jerampur. From the office of Assistant Engineer PWD Nampong, which comes under Jerampur subdivision of Changlang, your lordship. Your lordship, the impugn order, your lordship.
At page number?
That is at page number 56, your lordship.
Okay. He retired on who is that?
He retired on
16 November. No. Who is that?
your lordship. He retired on 31/10/2022, your lordship.
31/10/2022.
22. Yes, your lord. Before that, he received all the service benefits like gratuities and all. But when it comes for this pension, then several communication occurred between between his office to the audit and pension office.
So this amount was recovered from him.
No. It has not been recovered. Now, unless or until here, your lordship may see what they have given. The pay allowances are fixed by this office order so and so. It is seen that an excess amount of rupees 82,800 in leave encashment, 122,958 in gratuity, and 9,98,072 in refixation, which amounting to 12,03,830 only in total had been drawn by you, and the same to be deposited through treasury challan for settlement of pension.
Okay.
Now my pension is not settled because of this.
Because of this. Okay. This Rafiq Mas's case.
Yes,
State
sir.
of Punjab versus Rafiq Mas's.
And similar on the same line, your lordship, even Thomas Daniel has also given that if there is wrong fixation of pay, then it is the fault of the authority. So by referring this Rafiq Masi case, Thomas Daniel has also given the judgment.
That judgment is available with you?
Yes, your lordship.
That Rafiq Masi is available?
Rafiq Masi is available. I suppose this is available with the court also. In item 6, it was also discussed. I have also a copy of Rafiq Masi.
No, you show the direction.
Yes, sir.
To the government advocate.
This Thomas Daniel judgment, your lordship. It is at para 9, your lordship.
Yes.
Para 9. This court in a catena of decision has consistently held that if the excess amount was not paid on account of any misrepresentation or fraud of the employee, or if such excess payment was made by the employer by applying a wrong principle for calculating the pay allowances, or on the basis of a particular interpretation of rule order which is subsequently found to be erroneous, such excess payment of emoluments or allowances are not recoverable. This relief against the recovery is granted not because of any right of the employees, but in equity, exercising judicial discretion to provide relief to the employees from the hardship that will be caused if the recovery is ordered. This court has further held that if in a given case it is proved that an employee had knowledge that payment received was in excess of what was due or wrongly paid, or in cases where error is detected or corrected within a short time of wrong payment, the matter being in the realm of judicial discretion, the court may, on the facts and circumstance of any particular case, order for recovery of amount paid in excess. Now, in our case, there is nothing which has been given on affidavit that we are in knowledge of that. And since we are Group C, we come under Group C employees here. So this is a fixation of pay is not my cup of tea, Your Lordship. I'm just an assistant mason. It is fixed by the executives only, the authority only. Now, if they have wrongly fixed it, because even Your Lordship, there is an admission in the affidavit also. That is at page number, Your Lordship.
Okay, all right, all right.
That this is not disputed that because of wrong fixation of pay scale, this recovery is being ordered. This is not at all disputable, Your Lordship.
Okay. Yes, Mr. Lowang. You come to paragraph number 18 of that decision.
Yes, sir. Did you not know, sir?
Rafiq Masis.
Oh, Rafiq Masis. Yes.
You see, there's one recovery from the employees belonging to class 3 and class 4 service or Group C and Group D service. It is impermissible. And number 2 also cover the case of the petitioner. Recovery from the retired employees or the employees who are due to retire within 1 year of the order of recovery. So this order was passed on 16th of August 2024. The petitioner retired on 31st of October 2022.
Yes, sir.
So the case of the petitioner is covered by this situation number 1 and 2 of paragraph number 18 of the Rafiq Masis case, and also the paragraph number 9 of the decision of Supreme Court in Thomas Daniel versus State of Kerala and others. So what we do is we will set aside this order. You settle his pension.
Yes.
Within a period of 3 months.
Yes, 3 months.
Otherwise, it will carry interest at the rate of 9% per annum. Okay. Okay, we'll pass the order.
Deeply obliged.
Unlisted item number 21.
Your name, please?
And Sharma.
And Sharma. Yes, who is the petitioner? Unlisted item? Call it.
Unlisted item number 21. I have already called, Lordship.
Mr. Long, you are here in this matter?
I don't have the copy of petition.
You have not given?
No.
Petitioner is also absent. Who mentioned the matter?
I suppose one lady was there, Lordship.
One lady?
Yes. She knew because it will be listed here. In the morning only she have mentioned.
She is not here?
After lunch, I didn't see her. 22. Then it must be in code 5.
You are in item number?
22, Lordship. Okay.
Yes, in the morning you have mentioned this matter.
But then, Lordship, in the course, it's 22 item number.
Item number?
22.
22.
Oh, God.
But here it is 21. Okay. Oh, who is the petitioner?
Lordship, item number 22, I'm the petitioner.
What is the name of the petitioner?
Lordship, Dacha Bagang.
Whether you have served any copy to the council?
Yes, Lordship.
When?
Morning only I have served.
When?
This morning, Lordship.
Morning.
Yes.
Mr. Luang, you have not received it.
To the filing section.
To whom you have served the copy?
Lordship, to the filing section. This morning I given to the filing section to serve the other party.
Do you have extra copy?
Yes, Lordship.
Furnish him.
My Lordship.
So this page number 13 is the impugn order. What is the impugn order?
Lord, the transfer order is page number 13, Lordship.
13.
Yes, Lordship.
Tell me that. Here. Yes.
Page number 11 is the impugn order. You do not know the exact order also.
Lordship, apologize for that, Lordship. 11 to 13, 14, Lordship.
11 is the impugn order.
Yes, Lordship.
But why you are referring to page number 13?
Lordship, here is also by mistakenly, Lordship. Actually, it's page number 11, Lordship. By mistakenly, I have mentioned 13, Lordship. Page number 13. Page number, Lordship, it's a 13. 13 is a notification of the transfer order, Lordship.
13, he has been appointed as member secretary. You have not gone through the papers.
Lordship, I apologize, Lordship. This is a 13 is a notification where it's saying that please appoint the polling.
Appointment as member
Yes,
secretary of the local
town planning of district of state of Arunachal Pradesh.
Tune order is
page number
page
11.
number
11, Lordship.
But how long you were in Itanagar?
Lordship, 2 years, 2 years and 3 months, Lordship.
2 years?
2 years and 3 months.
2 years, 3 months.
Yes, Lordship.
And what is the difficulty in going there?
Lordship, here actually on the 3 ground, Lordship, I'm here. The first is, Lordship, I actually been suffering from the health issues since last 2 to 3 years. So that, Lordship, I even went to Delhi, Lordship, in the hospital. That is page number 20, Lordship. If you see that, Apollo Hospital for treatment, Lordship, where it's saying that I'm suffering from the this hypertension with the diabetes crystopathy, Lordship. If you see that page number 20, Lordship, specific. And from there, Lordship, even after Lordship treatment, Lordship, my health was not well, Lordship. Still, it was not recovery well. So that again, I have concern here in this Itanagar, in Hema Hospital, where the doctor is saying that, Lordship, if you see that page number 15, 15 Lordship, where the doctor is saying me that I have to undergo the treatment under the urology department monthly until recovery, Lordship. And I'm still on the undergoing treatment, Lordship. That is the first reason, Lordship. And the second reason is, Lordship, I have 3 minor children who is Lordship, that the youngest one is school going children. The youngest one is the eldest who is, Lordship, studying in LKG. And then the youngest one is in nursery. They're under the 3 of them children are completely depending on me, Lordship. Now my wife is alone, cannot be taking care of these 3 children, Lordship. And the third point is, Lordship, I also have my one widow mother.
Is there no school at Namsai?
Lordship, school maybe is there, Lordship.
Then,
Lordship, especially the problem is that regarding my health issues, Lordship. But then there's
whether doctors are not there at Namsai?
No, Lordship, the medical is not facilities are not in Namsai.
No, it is nearer to Dibrugarh.
Lordship, I cannot take risks on that because here the medical is more convenience for me, Lordship.
And any other ground?
Lordship, yes, my mother-in-law is also there. My mother-in-law, the widow mother-in-law is also with me. The reason the mother-in-law is also, Lordship, suffering from the health issues. Because of that, we are keeping her in here, Lordship. Because, Lordship, due to her present health condition, Lordship.
What is the normal tenure in a particular district or particular station?
Lordship, at least.
As per government notification?
2 years, you know.
2 years.
Yes, he has already crossed
you are more than 2 years here.
Lordship, only because of my medical condition, Lordship.
No. Medical condition, it is not your case that medical facility is not available at Namsai?
Lordship, because here already I am concerned with the Lordship doctor here, Hema Hospital doctor. It's my regular doctor, which I am always concerned.
Maybe that cannot be the ground for remaining here for your entire service period.
Lordship, at least for 1 year, Lordship. At least until recovery my health, Lordship. Lordship,
if it been a serious health issue, then it would have been different matter.
Yes, your lordship, it's just
Diabetology, the diabetes and hypertension. Everyone is suffering from diabetes and hypertension.
I agree, Lordship. Lordship, even a concern about my mother-in-law also.
No, that cannot be a ground. Mother-in-law. Whether mother-in-law falls in the definition of family?
Of course, Lordship.
Not there.
Lordship, she's my responsible now. She's with me and she's my
No, that's
responsible.
all right. But whether she is fall in the definition of family,
Yes, Lordship, it's definitely it really comes under family only.
yes, Mr. Ria, is it?
In my humble opinion, no, Your Lordship. In my humble understanding, Your Lordship.
Hmm.
So, at the best, Your Lordship, notice may be issued, Your Lordship.
Hmm.
Because since February 14, I think he has not been released from the ICR.
Heard, Miss, your name, please?
LG, Lordship.
Learned counsel for the petitioner and Mr. Riam for the respondent.
1 and 2, Your Lordship.
Respondent number 1 and 2. In this petition, under Article 226 of the Constitution of India, the petitioner has challenged the order
Yes, Lordship.
dated, transfer order dated 14 to 2026, number TP-ULB-1106/1/2022 DIR-TP within bracket E-41 380/4554-69 69.
Your Lordship, it's 11016. ULB dash 11016.
No, in the pair they have mentioned it.
Okay. It should be 11016.
Okay, yes. Okay, 11016/1/2022. The learned counsel for the petitioner submits that the petitioner is presently serving as
Director.
Serving as town planner in DC Capital Complex. No, in Itanagar, DC Capital Complex, and he has been transferred by impugn order dated 14th February 2026 to Namsai. The learned counsel for the petitioner further submits that the petitioner has been working in the Capital Complex Itanagar for 2 years, 3 months. And that and referring to the medical documents enclosed with the petition from page number
15 to
page number 15
to 20. 15 to 20, Lordship.
15 to 20. She submits that the petitioner is suffering from diabetes and also hypertension, and besides he has 3 minor children and all of them are studying in school, and the younger one is studying in nursery, and besides he has also he also has the responsibility of looking after his mother-in-law who is dependent upon him. And under such circumstances, she submits that the impugn order may be stayed for 1 year. 1 year. So that he can undergo the required medical treatment in what hospital?
Hema Hospital.
Hema Hospital.
Itanagar.
In Itanagar.
Yes, Lordship.
Itanagar. Per contra, Mr. Riam Learned, government advocate for the respondent, number so-and-so, submits that normal tenure of a government servant in a particular station is 2 years, as per government circular. But the petitioner is in Capital Complex, Itanagar, for more than 2 years, 3 months, 2 years and 3 months. And as such, Mr. Riram has opposed granting any interim relief. However, he submits that a notice may be issued at this stage. Para, having heard the submission of learned counsel for both the parties, this court has carefully gone to the petition and documents placed on record. Admittedly, the petitioner is in Capital Complex, Itanagar for 2 years, 3 months. And it also appears from the medical document enclosed with the petition that he is suffering from hypertension and diabetes, and the same is not of the serious in nature. And to a pointed query of this court, the learned counsel for the petitioner also submits that there are schools at the new place where the petitioner has been transferred. And thus, this court is inclined to issue notice to the respondents returnable in 4 weeks. Step be taken. However, no formal notice is required to be issued since Mr. Riram entered appearance for the respondent number 1 and 2 and received notice. However, extra requisite copy of the petition will be furnished to him during the course of the day. And since transfer is a condition of service, and since the petitioner is in the present station for 2 years and 3 months, while the normal tenure is up to 2 years, and since the grounds assigned for staying the impugned order appears to be not so cogent and reliable, and therefore this court is not inclined to grant any interim relief at this stage. This is the matter after 4 weeks.
Obligation.